The House will come to order. Members, today, Representative Basenecker will lead us in the Pledge of Allegiance.
Members, please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Amabile. Rep. Amabile.
Excused.
Armagost. Rep. Bacon is excused. Byrd. Bockenfeld.
Yeah.
Basenecker. Bottoms. Bradfield. Oh, Bradfield's excused. Bradley. Also excused. Brown. Catlin is excused. Clifford. Doherty. DeGraff. Degree Kennedy. Duran. English. Representative English. English is excused. Epps.
Here.
Evans. Frizzell. Froelich. Garcia. Hamrick. Hartsook. Representative Hartsook.
Excused.
Hernandez. Herod. Holtorf. Judah. Joseph. Kipp. Representative Kipp.
Excused.
Leader. Lindsay. Linstead. Is here. Luck.
Here.
Lukens. Lynch. Mabry. Marshall. Martinez. Marvin. Morrow. McCormick. McLaughlin. Ortiz.
Here.
Parenti. Puglisi. Ricks. Representative Ricks.
Excused.
Rutanel. Sirota. Rep. Sirota. Oh. Snyder. Soper. Story. Taggart. Titone. Valdez A. Velasco. Rep. Velasco. Vigil. Representative Vigil. Excuse. Weinberg. Weissman. Wilford. Representative Wilford. Wilson. Winter. Woodrow. Young. Where's she? Oh, yep, here. And Madam Speaker.
Here. With 54 present, 55 present, 10 excused, we do have a quorum. Representative Basenecker.
Thank you, Madam Speaker. I move that the Journal of Thursday, February 15, 2024 be approved as corrected by the Chief Clerk.
Members, you've heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All those opposed, no. The ayes have it, the motion is adopted. Thank you. Okay, members, we've got a little bit of business to deal with. Mr. Schiebel, reports of committees of reference.
Committee on Agriculture, Water, and Natural Resources, after consideration on the merits, the committee recommends the following. House Bill 1138 be amended as followed, and as so amended be referred to the Committee on Finance with favorable recommendation. Senate Joint Resolution 4 be referred to the House for final action. Committee on Appropriations, after consideration on the merits, the committee recommends the following. House Bills 1041 as amended, 1053, 1076 as amended, 1079 as amended, and 1258 be referred to the Committee of the Whole with favorable recommendation. Committee on Education, after consideration on the merits, the committee recommends the following. House Bill 1063 be amended as followed, and as so amended be referred to the Committee on Appropriations with favorable recommendation. House Bill 1039 be amended as followed, and as so amended be referred to the Committee of the Whole. House Bill 1087 be amended as followed, and as so amended be referred to the Committee on Appropriations. And House Bill 1049 be postponed indefinitely.
Thank you, Mr. Schiebel. Members, we are moving into business. Madam Majority Leader.
Thank you, Madam Speaker. I move that the following bills be made special orders on Friday, February 16th, 2024 at 9:15 a.m. House Bill 1098, House Bill 1122, House Bill 1041, House Bill 1100, House Bill 1076, House Bill 1053, Senate Bill 29, House Bill 1258, House Bill 1097, House Bill 1094, and House Bill 1130.
Seeing no objection, the bills listed by the Majority Leader will be made special orders on Friday, February 16th at 9:15 a.m. Representative Doherty. I think I heard that. I hope the rest of the chamber did. Seeing no objection, members, you have heard the motion. Representative Doherty will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the majority leader. The court rule is relaxed. Mr. Schiebel, please read the title of House Bill 1098.
House Bill 1098 by Representatives Mabry and Duran, also Senators Gonzalez and Hendrickson, concerning protections for residential tenants and in connection therewith, requiring cause for the eviction of a residential tenant.
Bill, I'll do my opening. And then
Majority Leader Duran.
Thank you, Madam Chair. I'd like to move House Bill 24-1098 and the committee report.
To the committee report. Members, it's very loud in here, so I'm going to ask you to tone it down, please. Thank you. Representative Mabry.
Thank you, Madam Chair. It is an honor to serve with you.
Honor to serve with you.
All right, members, we brought many amendments in committee to address concerns that we heard from stakeholders on all sides of this issue. And I'll sort of walk through at a high level what these amendments were. So the first amendment was getting rid of the relocation assistance in the legislation, clarifying that the notice period where an owner is intending not to renew because they're selling a home is 90 days and not 120 days. We included a shortened notice period for when an active duty military member needs to move into their home after the expiration of a lease. So their non-renewal notice will be a 45-day notice instead of a 90-day notice. Clarified what notices must be served regarding the language of the tenants. When they have to provide a Spanish language or another language notice. That was the first one. So the next one, we heard over and over and over and over again in committee and last year with this legislation that landlords were worried that they weren't going to be able to get tenants out who were causing a disturbance or a nuisance that violated the covenant of quiet enjoyment of other tenants. We heard explicitly this in committee. So we brought an amendment to address this. Also, it addresses this issue if the landlord lives immediately adjacent to the property, and we made clear that nothing in this amendment should be interpreted as creating a right to remove somebody who is a victim of domestic violence for police activity or things that are beyond their control because they are victims. We expanded the adjacent property exemption. I think folks will remember last year we had a long debate about duplexes, triplexes, ADUs. We have included within that if the landlord's primary residence is directly adjacent to the property, there's an exemption. We removed some of the language on mission-oriented and time-limited housing because it turned out it was antiquated. It was language that we had put in early on in response to feedback from them about housing that they were providing with COVID ARPA funds. They're no longer providing that sort of housing, so we don't need this language in the bill. We also brought an amendment that will allow landlords to offer tenants a longer-term lease. And if the tenant doesn't want to accept the longer-term lease with reasonable terms, then there is a 90-day non-renewal process, responding to feedback that landlords might want some more certainty that they're going to have their tenant in for a longer amount of time rather than them being sort of perpetually month to month. And then we included a no-fault non-renewal reason if the tenant is habitually late. If they're late more than 2 times within a lease period, we have included that the late payment doesn't count if they've cured within the cure period. And we wanted to make sure that there were safeguards for folks who maybe got sick or had a relative died, so made sure that it's more than 2 payments and that the cure period renders that invalid. We have clarified that this doesn't apply to workforce housing, and the protections here only apply to known tenants who have lived in the property for at least 9 months. So that is the committee report, and with that, we urge an aye vote on the committee report.
Is there any further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report passes. To the bill. Majority Leader Duran.
Thank you, Madam Chair, and it is an honor to serve with you.
An honor to serve with you, as always.
Members, I'm honored to join my co-prime sponsor, Representative Mabry, on this bill. This legislation is deeply personal for both of us, having experienced evictions ourselves firsthand. We have worked hard to ensure that landlords still have the tools they need to deal with tenants who are not following the law or their lease. But both Representative Mabry and myself feel this bill is a necessary step towards protecting the sense of stability and community that our working families and renters deserve in Colorado. We would like to thank all the stakeholders that engaged in this process and the conversations. As many of you know, I'm a survivor of domestic violence. After I escaped my abuser, I struggled to make ends meet as a single mother. I vividly recall the sleepless nights spent worrying if I was going to be able to pay my rent, provide food for my son. It was an ongoing thing that was on my mind. The thought of having to find another place to live that I could afford and come up with a deposit, first and last month's rent, added to the emotional turmoil I was already experiencing from leaving my abuser. Ultimately, I did get evicted, but not because I couldn't pay my rent. It was because my landlord didn't want to continue renting to me. I had abided by all the rules, paid my rent on time, and I didn't deserve to be evicted. My son was forced to leave the school and friends that he knew, which was actually the only stable environment we had both known for a long time. My son and I were homeless, and our possessions were thrown out on the curb as if they were trash. I gathered what I could fit in my car, along with what was left of my pride, and I resigned myself to living in my car. No mother or child should repeatedly endure this kind of anxiety and stress. But under Colorado law as it stands now, a landlord doesn't have to give you a reason to evict or not even renew your lease. Having an eviction on your record can make it nearly impossible to find stable housing. According to research from the Eviction Lab, hundreds and thousands of families in the United States are evicted every year. Women, families, and children, families of color, families with low incomes, and families living in urban areas are more likely to be evicted. And households with children between the ages of 0 and 5 face the highest risk of eviction. My son and I were part of those statistics. As someone who has been evicted and lost the roof over her head, I want tenants facing the same thing to know that I am sponsoring this bill because we as a state can do better. Unnecessary evictions perpetuate the cycle of abuse, poverty, family, instability, and have impacts on mental and physical health of our families and our children. Our for-cause eviction legislation will prevent arbitrary, retaliatory, and discriminatory evictions of clearly defining into law what a landlord may evict a tenant for, including non-payment of rent, property damages, violation of the lease agreement. Our bill will also ensure tenants have more protections when a landlord doesn't renew their lease at the end of the lease term. This framework strikes a delicate balance. I repeat this, it strikes a delicate balance. Protecting the rights of both tenants and property owners, and that will keep Coloradans housed. It's not an attack on the free market. Please know that, my friends, it's not, but rather a sensible approach to safeguarding a fundamental human right, a right to be safe and have stable housing. My journey fuels my passion, as it does for many things here, in championing this bill with Representative Mabry. This legislation sends a powerful message about our commitment to the well-being of our communities. We know voters across Colorado are concerned with the cost of living, putting food on the table, and keeping a roof over their families' heads. By enacting for-cause eviction protections, we can foster a state where families can flourish, children can learn without disruption, and households can experience more stabilities. I'm calling on the legislature today and all of us to enact for-cause eviction legislation to bring systemic change to our housing landscape, protecting our communities, and protecting all those other Monicas out there. Thank you.
Representative Mabry.
Thank you, Madam Chair. Members, I hope that everyone here wants to do everything in their power to prevent unnecessary evictions and save families money. The legislation that we are introducing today does these things while placing no financial burden on landlords. This is the right thing to do, and I believe that we can get this done this year. Matthew Desmond, head of the Princeton Eviction Lab and author of the best-selling book, Evicted, reminds us that this country locks men of color up and women of color out. Last year, Denver saw the highest number of evictions since the city started collecting this data in 2008. I want to highlight that. That means there were more evictions last year than during the Great Recession. But these aren't just numbers. Each represents a real family. And right now, Colorado landlords can evict their tenants for any reason or for no reason at all, even if the tenant has paid their rent and done nothing wrong. No laws exist to protect from no-cause evictions. In committee, and over the course of this year and last year, we heard from families who have seen firsthand the devastating impact that this lack of protections can have. We heard from families who were removed based on the color of their skin or because they made valid complaints about problems in their homes. I have been in court and gotten evidence of racial discrimination admitted on the record to the point where a judge agreed with me that racial discrimination occurred. That judge still ordered an eviction because racial discrimination was not a defense to an eviction based on the termination of a lease, even though the landlord renewed every other tenant's lease on that property. I've also seen firsthand how victims of domestic violence are unfairly targeted by these sorts of no-fault evictions simply because police came to the property too many times to respond to active violence that were no fault of the victim. A for-cause eviction law would clearly define in state law when and why landlords can evict tenants. This will stabilize renters and prevent unnecessary displacement, discrimination, and retaliatory evictions. This law creates stability for landlords and renters because it does not prevent landlords from evicting tenants who have violated their lease or who are behind on rent or where a landlord is getting out of the business. This will save Colorado families money and keep roofs over their heads and roots in their communities. Housing instability can and does damage a child's school performance. Compared to their peers, homeless students and those with high rates of housing instability perform worse in school and drop out more. I know this firsthand because I dropped out of high school after my family was evicted and we were homeless. And that's why I care so deeply about this. Another thing I want to highlight is that the United States Congress passed the Fair Housing Act to prohibit housing discrimination against children and families on the basis of race. But this is a front-end protection. There are no back-end protections in Colorado to prevent the removal of renters who have done nothing wrong. In the absence of federal action, we must step up. And this is a critical back-end protection that will prevent vulnerable groups from being targeted for eviction. If we are interested in identifying and preventing discrimination, we should focus not only on the freedom to obtain housing, but the freedom to maintain housing
And this does just that. And it's the least that we can do. I want to highlight how this is such a critical anti-discrimination policy. So practices used to demonstrate discrimination in the rental market are useless when it comes to preventing eviction, if not impossible to prove discriminatory intent when the landlord does not need a reason to remove or evict a tenant. Yes, we have anti-discrimination laws in this state. Yes, we do. But the process of proving that discrimination has happened moves far, far, far slower than the process of eviction. If the state or a plaintiff's attorney or the tenant themselves can gather evidence of large-scale discrimination or prove that the landlord's bias led to their eviction, the person would most likely already be out on the streets facing the lasting consequences of eviction, housing insecurity, and homeless, and the damage to families and children will have already been done. Even if we were to strengthen Colorado's anti-discrimination laws and put in housing-specific state law around discrimination and aggressively enforce these laws with significant money and government resources, we would still be operating in an eviction system that allows landlords to evict tenants at the end of a lease or on a month-to-month without giving a reason. This makes it almost impossible for a tenant who is already facing the threat of eviction to take time to try and find the specific evidence for their case to keep them housed. Finally, there are currently anti-discrimination laws on the book. Again, the Fair Housing Act has been the law of the land for 50 years. It is already illegal to discriminate in housing, but that has not stopped discrimination. A study from the National Bureau of Economic Research across 50 U.S. cities recently reiterated this point when it identified discrimination against Black and Latino housing applicants. The Fair Housing Act can provide consequences for this discrimination, but stopping evictions from happening is not one of those. And as I have seen, even if you can prove what is also often impossible to prove in court, that the tenant faced direct and intentional discrimination, that was the reason for eviction and removal, it does not matter. Because a landlord can evict for any reason in Colorado. And so while I agree that we should work to strengthen anti-discrimination laws both at the state and federal level, let's first pass a policy that will directly prevent discriminatory, arbitrary, and retaliatory evictions. Let's pass for cause to prevent discrimination and protect Coloradans from the harm of eviction before it happens and before children and families and young people trying to build their lives have those lives upended. We urge an aye vote.
Representative Holtorf.
Thank you, Madam Chair. It's an honor to serve with you.
Honor to serve with you.
You just made my day brighter. Thank you. In an already cloudy day, I rise to speak to this esteemed group of representatives to talk about some of the issues and concerns that come from my caucus and my constituents. Now, there's a lot of claim of racial discrimination. There's a lot of demographic data that's put forth here that's discussed. But I will tell you there are many people in that demographic, including people that I know, that are not having issues with tenant-landlord relationships. You see, the best way to not have a problem in this space with respect to evictions, number one, is to pay your rent on time. Number two is to not violate the conditions of the contract that you sign. In almost every case, if you do those two things, with a few exceptions, you will never have a problem. You will be able to stay in the property, and you will be able to thrive and flourish. Now, there are a few exceptions, and some of those were presented. Those are exceptions, not the rule. But you have to understand that for those people that are landlords, it is already very difficult and I don't think the bill sponsor properly represented this. It is already very difficult for any landlord to evict any member, and it oftentimes, as he knows, because he is a lawyer in this space, and there's a concern about a 21C consideration with these multiple bills that are brought forward, but he is a lawyer in this space, so he knows that oftentimes these tenants go to court 1, 2, or 3 times, just so you know, to court before a judge before they are evicted. So there is a lot of legal support in this space for the tenants already in Colorado. And there's a great amount of consideration from the judicial system to take care of tenants so they are not cast asunder. Now, nobody today was going to present that evidence. It doesn't meet the narrative of the bill sponsor. It doesn't fit in that box. Now, I am very glad to the majority leader, because when we first saw this bill introduced, it was very detrimental to landlords, to property owners, to those that are offering those homes to the very people that the bill sponsor wants to protect. Now, in my district, I have had many people say, and even outside of my district in Colorado, that they are leaving this economic sector. They are leaving the rental business. They are divesting themselves of their property because this is no longer a friendly business environment for those people to do the business they do. Now, this is a real problem economically. Many times I have come up here and I spoke about the second and third order effects of legislation as we let emotions drive us, as we have compassionate pleas to pass legislation that helps those that arguably need the most help. But what you fail to recognize is the collateral damage that you cause when you continue to chip and chisel away at this sector, because that is what you do. I had one person tell me they have over a dozen properties right here in the Denver metro area, perhaps even in the bill sponsor's district, or maybe both bill sponsors' district, that they are going to sell, and they're leaving Colorado. They're leaving Colorado, they're taking their toys and going somewhere else. Not to be cynical, but people make choices. And you are driving capital investment and landlords and those that provide the homes and put the capital up to own these properties out of our state. All in the spirit of doing good. All in the spirit of trying to help those that arguably do need the most help. But let me wind this up where I started. If you pay your rent, and if you follow the terms of the contract, 9.9 times out of 10, the landlord will never ask you to leave because you are a good tenant. And in Colorado, now more than ever, landlords need good tenants. People that don't damage the property, people that follow the rules, people that pay their rent on time. Now, I understand there's economic issues that are out there. And we have in this very chamber put many, many bills forward. In fact, one of the bill sponsors has been bringing those bills to provide grant programs, funding, state funding, all these resources to help these people. But that is not enough. We have to turn it back on the landlord. Now, there's a few amendments here, and I'm very happy for the amendments, and so are all the landlords in Colorado. They are very happy that one of the bill sponsors stepped up and said, we have to fix this bill and dress it up and bring it together in a way that is responsible for Colorado. And I thank that bill sponsor for doing that. She is an amazing leader in this chamber. And I'm very proud to serve with her. Now, I don't want to get into all these particular amendments. But I will tell you, many of them are good. Dual language is good. We have a large Spanish-speaking population, and they can't read English. They may speak English, but they can't read it. And it may be broken English. So that does help. I am proud of that. You know, the 10 days notice, the 3-month notice, those are already offered through the judicial system, or this 90-day notice, or the 90-day provision rather. But beyond that, is the rent continue to be paid? Because if it is not, ladies and gentlemen, that's 25% of the calendar year and 25% of the revenue that the landlord is expecting to maintain that property. And oh, by the way, to my good bill sponsors, let's not forget that the property tax on that property that they are managing and owning has gone up 20 to 40%, depending on where you live in Colorado. And someone has to pay that. Who pays that bill on that one property or 10 properties? Who picks up that financial burden when arguably some of the tenants aren't even paying the rent as they go through the process? So I'm going to turn this over to some of my other colleagues that have other concerns. But I will tell you that we need to stop the train, the freight train of legislation that comes in this space. And I would hope that there's no member in this House that is going to profiteer from any legislation that they pass in this chamber, because that is against the law. Thank you.
Representative Marshall.
Thank you, Madam Thank you, Madam Chair. It's an honor to serve with you. I rise and come down real quick just because of disturbance of being told my friend and colleague from Denver is in a 21C violation. That does go straight to the bill, if it was true. But our colleague from Denver is an eviction attorney, and if this does increase the workload, it is only going to be a detriment because of the amount he puts in personally to help these individuals that are being and facing eviction. There are very few people, I think, that are more honorable that I know of in this entire chamber than my colleague from Denver. And I frequently disagree with him, often vote against him on many things. I may not even be able to get there on this bill as much as I'd like to, but he is one of the most honorable men in this chamber. Thank you.
Representative Frizzell.
Thank you, Madam Chair. So I heard this bill this week in committee, and I want to say how much I appreciate the bill sponsors' work to bring this bill to a place that's a lot better for property owners who lease property and property managers. So I really do appreciate it. I believe that our colleague from Larimer County held up the amendments during committee and spoke about his admiration for the body of work that is in this bill. So in committee, we heard testimony. We heard a lot of testimony, as you might imagine. It was a late night. And some of it was really, really difficult to hear from both sides. We heard from individuals who were treated horrifically by their landlords. Horrifically. No human being should ever treat another human being that way. We also heard from property owners who have experienced tens of thousands of dollars of damage to their property that they own due to negligence and malicious behavior on the part of their tenants.
who sometimes they couldn't even get to leave. And in fact, they chose, rather than go through the eviction process on some of these individuals, they chose to just not renew their lease when it came to term. It was better for the tenant that way and better for the landlord, in their opinion. So all this said, I'm still very, very concerned about this bill, and I'm going to tell you why. I asked myself, at what point is this no longer the property owner's property? They do not have equal treatment. A resident cannot renew, but that's not true of the landlord in this bill as amended. I heard in testimony something that I found really interesting I hadn't contemplated before. And that is that these small landlords, these mom and pops, who operate on a small scale, maybe they just have 1 or 2 places that they rent, maybe they just have 1. But they are having to contract with property managers rather than manage these properties themselves, just to navigate the complexity of Colorado law. The last several sessions have seen us pass complex and onerous and sometimes punitive laws. I'm sure that could be argued whether it's punitive, but from the landlord's perspective, that's how they feel. They feel like they're under attack. Because if you can't navigate Colorado law to rent your property, you're so afraid that you're going to slip up and do the wrong thing, and you go to a property management system, that has the ultimate effect of increasing the rent. Property managers don't work for free. And that increase in cost has to be passed on. I worry about this. I've spoken about this in the past from this very podium. If we continue to increase the risk that landlords have to bear, the small folks are going to sell, and they are. They are selling. We heard testimony about that just this week. We heard from a landlord who owned a few properties, and she's putting them all on the market. She's out. If we increase the costs of doing business and costs and the risks for landlords, they're going to leave. They are leaving, and it's also going to increase the cost of rent. This is not making Colorado more affordable. Thank you very much. I ask for a no vote.
Representative Winter.
Thank you, Madam Chair. So after speaking to a lot of my constituents, we dealt with this issue last year, and still the one thing that resonates out of my district from Pueblo all the way down in the Eastern Plains is feels like this is an attack on the little man. The little landlord, the landlord that is, like I said last year, having Thanksgiving and Christmas with their tenants, the landlord that looks like them as family, and they truly believe they're doing the right things. And they feel that they're getting caught in this whole, 1,000 apartment complex, corporate world talk. And out in rural Colorado, House District 47, in my district, I spoke with people on both sides of this issue. And they just feel like, once again, legislation that is meant to fix problems in the Metroplex, in big cities like Denver, Fort Collins, and Greeley, is legislation that trickles down and comes on their back. And they feel like that they're doing the right thing. and that they're being punished or they're being looked at in the wrong light or being portrayed the wrong way for something that they're not doing. And there is something about country living and the way we treat each other. You break down in Denver, Colorado, chances are somebody's not going to stop and help you. You break down in House District 47, chances are everybody's going to stop and help you. And all I ask is that when we look at these problems and we discuss these issues, that we look at the full spectrum of who these people are. Because at the end of the day, it may not be a big deal in these chambers when we talk about it, but these people take this stuff personal. Because they have ethics, they have values, they have families of their own, and they care about people. That's what rural Colorado is all about. And I wish you all could travel and see that. Because like I've said before, and I'll say a million times, fixes for big city problems have consequences for rural Colorado. So I'd be a respectful no on this. Thank you.
Representative DeGraff.
Thank you. Madam Chair, it's a privilege to serve with you. All right, what we have is a brand new bill. We have a brand new bill from yesterday. And I would like to believe it's a solution, but we've been led down the primrose path before of that you have to pass it to find out what's in it. And I like to go with, if it's a good idea, we have time to sit on it. This was not law yesterday. The state will survive until we can make sure that we have a good solution, not just an expedient solution. 16 amendments. 16 amendments went into this bill. Presumably, I'll presume that it makes the bill better. Presumably, it makes the bill less bad. What would be bad about this bill? Well, it's got good intentions. As one of my favorite authors, Karl Marx, said, the road to hell is paved with good intentions. I have a personal friend. It took months. It took months to evict somebody. That was before these laws. It took months to evict them for doing damage and causing disruption. They could not get the people out. It doesn't sound like they need more protections. It sounds like the landlords need some protections. But this makes the sweeping generalization across all the landlords. And surprisingly, what landlords want to do with their property is they want to make a modicum of money. They want to make a little bit of profit, or at least break even, so that they can continue owning that property and they can continue that service. And there's a lot of people that like to rent because you don't have to pay the 2%, which now, or the 6%, which now would, on a purchase, which is now going to run you close to $30,000 on an average price home. And they would prefer to put that into a rental, because not everything that goes into home ownership is building equity. And we have people that are providing a service, and that service is inviting somebody into their home. Whether they live in it or not, they are inviting somebody into their home. And it is pretty commensurate, first, on the individuals, again, I mean, there's going to be stories. There's going to be bad apples there. There's going to be bad renters. Oh, going back after the renters were finally removed, they appealed to the Alzheimer's father. He let them back in. And then in the time frame that it took to evict them again, there was some normal wear and tear on the apartment, which totaled over $80,000 in damages. I mean, sometimes you just spill red paint all over the laundry room, and sometimes you just fill the toilets with concrete, and sometimes you just rip all the sinks off the wall. Those things happen in the course of normal day-to-day wear. There are as many horror stories about renters as there are about landlords, perhaps more. So I don't want to be just knee-jerk opposed to this bill, but I don't even know what's in it at this point. When I told my neighbor last year, who's from New York, mentioned some of the rent control bills that we're going through here, first thing he said, they'll turn them into condos. They'll sell them. Take them right off the market. Why? Because we have an extensive history of knowing that. Now, how somebody who works in the eviction space can't know that history is a mystery to me, because it's well documented. And what happens when you take properties off the rental market? Well, Econ 101 says when you reduce the supply.
Representative DeGraff, could you talk to the bill, please?
Yes, ma'am. To the bill, what these bills do, what this bill does, is it reduces the supply. So when you reduce the supply, you increase the cost. That's not a matter of evil landlords. That's a matter of economics. Now, what would actually help, since we're trying to help, is the rent. Last year we heard that the rent was driven up by 25%, and it's like, oh, well, taxes went up 25%. Then we have other bills that say, well, you're going to have to give, and these bills all tie together. So I can't really, so yes, you can speak to this bill, but this bill has relations with other bills. For instance, driving people out of the market. If you drive people out of the market, now we have legislation that says all occupancy limits are arbitrary. That makes all properties multifamily. And then a bill that's going through the Senate now would mirror what came through last year about giving first right of refusal to nonprofit donors. And those nonprofits would then have a property advantage of not having to pay the taxes to the school, and the schools would become, and the other things that are funded by property tax would go unfunded. Well, the nonprofit organizations who have boards of directors that somehow make all kinds of money retain an advantage. And they do what? That puts other small businesses out of business. So these bills, so in that sense, I'm speaking to these bills because we have 500 bills that all tie together. They tie into the CRS. This bill will go into the CRS. It will go into the body of law. And then it will be assumed constitutional unless a group of people decide to go and challenge it in court at great expense to themselves. They have to make a determination as to whether that expense to themselves is greater than the expense of this bill. Yes, there are horror stories about landlords. And the best way to handle horror stories about landlords is to have a robust market. And this body, this General Assembly, is doing absolutely everything it can to make sure that there is not a robust market for these, and it's driving the prices up. Things in here like reasonable terms. What does reasonable terms mean? I'll tell you what reasonable terms means. Reasonable terms means litigator's dream. A litigator that can take any case and they can take it to court for $200 to $500 per hour. Litigator's dream, that's what that means. It doesn't mean anything. And then you say, well, we can't have unreasonable terms. Well, who's the person that makes the unreasonable terms? When somebody determines that your house has a room that could be rented, are you compelled to rent it? Once you open an Airbnb, you want to list your room for an Airbnb, does that mean your house is for permanent rent now? What are the ramifications of this bill that nobody's going to think about and pass anyways? The road to hell is paved with good intentions. I think some of the intentions of this bill are good, not all. I talked to a rental agency last year. They had looked at building a 300-unit complex in Colorado Springs. They wanted to build a 300-unit complex, over 300 units. And then they looked at the laws that this body was proposing. And guess what they did? They left. They pulled up tent stakes and they left. There's 300 units that didn't go in. So who's driving up the cost of rental? Who's limiting the house? This bill is trying to undo the damage that this body is doing. And how do they do it? Do they do it by lowering taxes and making prices more affordable? Do they do it by unrestricting energy where people can actually afford their heating bills? No. What this body does is the summation of the agenda, which is the elimination of private property. Every single thing leading towards the abolition of private property. This bill talks about, the sponsor said, systemic change. That's like saying a foundational change, a system at the very core, not a tweak, but a systemic change, a foundational level change. We're not changing something in the structure, we're tearing apart the underlying foundation. The underlying foundation here is property. We have 5th and 14th Amendment rights that no one should be deprived of property without due process of the law. This is not due process. This is the legislation saying that you don't have the right to do with your property as you see fit. When somebody has a contract and it's not renewed, when you sign a contract, that's what the contract is. It ends on the day the contract ends. That's not mean-spirited. And then you have two people individuals. So now we have this whole thing into contract law. If this body can insert its good intentions into contract law between a landlord and a renter, why can they not also interject their good intentions between, say, a loan company and the individual who owns a vehicle? Because taking somebody's vehicle for things like not paying or anything like that also creates a problem for that person. Not paying on time. What are some other contract laws that we could, there's lots of contract laws. Because now you're just saying the state has the precedent and it's constitutional. It's not. But we have a system that declares laws constitutional unless they're fought back by the people who don't even know what's going on in this body, who it is my feeling that most do not know what's going on in this body. Because they expect that people, when they take an oath to the Constitution, don't have a page of scruples that they're adhering to. This is a violation of contract law. It's an eviction attorney's dream. And then we throw in, to justify it, inflammatory statements like lock color up, lock women out. That has nothing to do with the contract law. We're trying to solve a problem here with contract law, and the inflammatory language that's allowed to stand is a gross generalization of the landlords and their intent. Again, the best way to handle this process is to create a robust market. And the robust market is not by rent control and landlord and quashing of landlords. There are lots of people that want to rent. I know lots of them that will not rent right now because they won't rent rooms, they won't rent properties. So the people that are willing to take that risk based on what this body is going to do are charging more. And instead of solving the problem, which is you're punishing the people who are actually providing a service. In the free market, it's an exchange of good for good. The free market is a good for good. It's free because it does not have to be compelled. We do have protections. It is unfortunate we have to use them. We do have protections in every bit of contract law. I think we need to look at just how much of a chunk out of contract law this bill takes. On the issue of precedent, it takes a lot. So this is going to be another feel-good bill. It's kind of like when you pass a bill for $30 million to give $50 one time to a group of people and then call it tax relief. It's a feel-good bill that accomplishes nothing. This bill, my fear, having not been able to read it because it's a brand new bill since yesterday, is that this body, you, are going to make the problem worse instead of better. Because you never look at what you've done to the market that is causing it to be this way. You just look for more government solutions. And there is no problem that the government can't make worse with a solution. Especially an imposed solution like this, especially as a one-sided solution like this, that does not treat everybody, that does not treat both sides of a contract equally under the law as the Constitution requires. This bill shows favoritism, shows deference. That's unconstitutional, it's unbiblical. If you want to look at it, whether it's inspired word of God or the archetypal compilation of things that have worked over the years, either one is a little bit risky to violate. The law is supposed to be blind. The law is supposed to be blind in all cases. This puts a heavy foot on the scale. That makes it unconstitutional in and of itself. But since being unconstitutional, I believe, doesn't bother all that many people in this building, and that's just a personal belief, I think what you should do is you should look at what we should evaluate. We should step back and evaluate and undo the stuff that this body has done as opposed to adding on to it, because what you're trying to do here is you're trying to cover over a symptom of a disease that you've created, and that disease is the General Assembly.
Okay, Representative DeGraff, let's not impugn anyone's motives. Let's stick to the bill, please.
Thank you, Madam Chair. I don't know why the General Assembly does what it does. I won't speak to the motives. But I can speak to the fact that the problem stems from the rules that are created in the General Assembly, and then instead of fixing the rules, instead of undoing the damage, what you do is you pile on more. And you pile on more complexity. That complexity drives cost. As my colleague mentioned, we have to now hire property managers. Those property managers cost. You can't just enter into a handshake agreement with somebody that they're gonna abide by you need a 15-page contract. That costs money. A 15-page contract costs money to enforce. That drives up the cost of rent. That makes rentals less available. So the solution is more government. The solution of this General Assembly is always more government. More government is more cost. More cost is less availability. The market is already fouled up beyond anything recognizable. as free market. So when somebody says the free market has failed, the free market has not failed. The General Assembly in this rental space has destroyed the free market, has created a problem, and has compiled the problem with more bad ideas. I think we need to take a step back. We need to look at this. We probably need to talk to landlords and figure out why they would kick somebody out. That's what the legal process does. So as much as I would like to vote with well, one, I don't even know what's in the bill yet, so I can't. And two, I don't know that it's not going to do more damage, and I suspect it's going to do more damage than the good intentions. And I cannot vote for a bill based on good intentions.
Representative Wilson.
Thank you, Madam Chair. I was in committee on this bill, and there was a couple things that kind of concerned me about this bill. One is that we've now taking the contract and started calling it an eviction. A contract is a contract. Contracts end. Not every contract is in perpetuity, and we need to realize that you create a contract with somebody to live up with that contract agreement. The other thing we heard a lot about in committee was that last year we had more evictions than ever, but yet it was stated by the sponsors that this would only affect about 5 to 7% of those evictions. In reality, with the changes in the bill, it's probably less than 5%. So we're talking about, we've had the highest number of evictions, but this won't address that. This doesn't do anything for that. I thank the bill sponsors for the amount of changes they have made to this bill to make it more palatable for our landlords, our mom and pop home renters. I do have one question for the bill sponsors. But I'll save that. Thank you.
Representative Armagast.
Thank you, Madam Chair. In the light of what this bill is doing, we're talking about taking care of people that are in crisis, that are potentially being evicted from their homes, that are potentially losing what they need, a roof over their head, shelter, all their basic needs. These people that are in crisis, I think if we're really talking about taking care of them, we're talking about the opportunity for them to be able to get the representation that they deserve. And with doing that, I think that we have to acknowledge the fact that we aren't making them victims after they've essentially been victimized. So I would like to move L017 and ask that it be properly displayed.
L017 is properly displayed. Representative Armagast.
Thank you, Madam Chair. So what this amendment is essentially doing is saying, if an attorney is going to represent one of these tenants that's in this crisis, that shouldn't be a profitable thing. That should be something where we're helping, like this bill is intended to do, we're helping somebody that's in crisis. So in doing that, we're not going to be gouging these people that are struggling and suffering, and that we should not be charging them more than $25 per hour for this service, for the protection that they deserve in getting the help that they need. So I would strongly ask for a yes on this amendment so that we are making sure that in every angle we're taking care of these people. Thank you.
Representative Mabry.
Thank you, Madam Chair. This amendment is entirely unnecessary and demonstrates a lack of understanding about how the process works here. Tenants don't pay for attorneys. That's not how this works. Attorneys are provided for free by nonprofits. No attorney could do an affordable practice in private practice representing tenants who are getting evicted. That's not how this works. It's nonprofits providing free legal services. That's what I do. We provide free legal services, so this amendment is not necessary.
Representative Bottoms.
I do support this amendment, and if what was said is true, then there would be no reason to not run this amendment. This would just be a stopgap in case for some reason the nonprofits did not step up to the plate, and this is something that somebody is needing to do. We've got to look out for the little guy here. We've got to look out for those that are being economically depressed by all this stuff. If they can't pay their rent, then there's probably a financial reason why this amendment should be applicable. And so I think this amendment is right on target. Let's look out for the little guy. And somehow, if the nonprofits don't make it, then we still have this stopgap. So in the argument of decency and caring for the little guy, I strongly support this amendment.
Representative Mabry.
Thank you, Madam Chair. I want to respond to that point real quick, and I don't see our colleague from Washington Park, but another reason why this amendment is completely problematic is another way that this works is if a tenant's attorney or a nonprofit organization is in a case and the landlord is found to have done something particularly egregious, like illegally evicted their tenant, like changed the locks without going through the court process, which is particularly devastating, in which this body has said specifically require statutory damages, attorneys' costs, and fees. What will happen is the ability of nonprofits and attorneys to hold bad actors accountable under the attorney's fees clause, where people are egregiously acting, will negatively be impacted. So this amendment will do damage to the already weak system that we have protecting the most vulnerable.
Representative Lynch.
Thank you, Madam Chair. It's an honor to serve with you.
Honor to serve with you.
So I think our colleague misspoke there in that there's no fees applied to the tenant themselves. What this does is this ensures that we have the litigation coming from a good place in the actual attorney's heart. And maybe you can clarify that, but the way I understand it is there's no cost assessed to the litigant, but I would be really shocked if the lawyers receive absolutely nothing for this. So if he could expand on that, on the fact that there's no fees to the person that's in the suit, but the lawyer themselves will get paid from that nonprofit, is the way I understand it. I'd love some clarification on that.
Representative Holtorf.
Thank you, Madam Chair. I'm going to respond on behalf of the bill sponsor. That may not be a fair question, although it's a good question. May not be a fair question. But we know that lawyers get compensated very well. Even the ones in the nonprofit space, I don't think all of them are working pro bono. Because if they were, they'd have to walk to work. And most of them drive very nice cars, live in a very nice home or apartment or condo.
Representative Holtorf, I'm giving you
Yes, ma'am.
wide latitude, but if you could please speak to the amendment
Yes, ma'am.
specifically.
Yes, ma'am. Thank you for your leadership. So I want to talk to the amendment and not get too hogtied about how much lawyers make, because last time I checked, they do awfully well for themselves. Now, this amendment, I think it absolutely helps the little people. The little people, because not every lawyer that's doing this it works for a nonprofit. A lot of people want to work for nonprofits. They pay pretty well, I've noticed. Maybe when I retire, I'll go work for one, ma'am. I don't know. But I will tell you that this amendment right here $25 an hour. If you want to help the little people, that's a good rate. Now, the lawyers out there are kind of cringing, going, oof, oof. That's like me selling cattle for 25 cents a pound. Oof. I understand that. But people want to put regulations and laws in to control all these different business sectors. And arguably this legislation in its introduced form was very onerous. In fact, in Spanish, for those of you that speak it, que fue muy pesado para la industria, muy pesado para la gente que tiene la propiedad, que está intentando arrendarlo. Mucho, muy pesado a madre, pero hasta el suelo con el peso. Now, you're going to have to get a translation, so I'll let somebody, if they want to translate, they can come up and do that. But it's true. But this takes away that weight. If you understood me in Spanish, that heavy weight, that burden that presses down on the little people. And those lawyer fees that come, if you've ever had to pay one, and I have more than one time, those things are scary. $300, $400, $500 an hour. I won't go into an auctioneer's chant, but that's what came to my mind. Now, $25 to help those folks. If we pass a bill like this, I think we're helping the little people. We can all agree. And we can fix that price for those attorneys that in this particular bill are doing this particular business. Thank you, Madam Chair, for your latitude. I appreciate your kindness. And to my good friend from Wellington, I think I might have been wrong in my first statement. I might have been wrong. I'll go sit down and think about it, and I'm done speaking. Thank you.
Representative DeGraff.
Thank you, Madam Chair. I think this is an excellent amendment. I think it comes from the right place. I think it comes from a good heart. I think it comes from I think this should be considered a friendly amendment, which is really a surprise that the sponsor would consider it not a friendly amendment. I do like the part that he said no lawyer could afford to run a practice on that. And so now we're supposed to take pity on the legal side, who's raking in between $200 and $500 an hour, more or less, I don't know. But we've completely negated the part where no landlord could run a property based on these rules. So we're taking aim at the property owners for the purpose of the abolition of private property. And we're taking pity on the lawyers, not the renters who are providing a service in exchange of good for good that sometimes goes bad, but on the lawyer side. And we've all heard the terms about ambulance chasing. That's just a term. I'm not assigning motive. It's just a term. And the sponsor said the nonprofit pays the lawyer. So the lawyer is making money. The nonprofit somehow has enough money to pay the lawyer to go against the landlord, because who then pays if the landlord has any damage, if there's a finding? Well, the landlord pays, not the nonprofit. So there's part of this. What this would also do, this limitation on the fees paid by the lawyers, which are paid by the nonprofit, and lots of people live on less than $25 per hour. Justice would still be done. Justice could still be done. The locks could still be changed back. We'd actually probably have even more cases at $25 an hour because people could afford the lawyer. By allowing lawyers to charge $200 to $500, aren't we just really restricting the right of the people to seek redress to their grievances? It feels like our primary protection here is the legal field. Seems. Sure seems, sure looks, sure appears. So a yes vote against this amendment is really a vote for frivolous lawsuits, frivolous fishing lawsuits. Frivolous fishing lawsuits that drive up the cost of rent because they drive up the cost of insurance and they drive landlords out of the market. So again, here you have an opportunity to actually do something positive for the market. You won't, but you have that opportunity. It stops costs from being driven up, helps make rent actually more affordable. This would actually do something to help make rent more affordable. Finally. And again, this does not preclude justice being done. This just prevents the practice of frivolous lawsuits looking to get something out of someone to offset the costs, with the ultimate goal of the abolition of private property. So here's an opportunity. Are you going to vote against the landlords again? Or are you going to vote for this amendment, for something that will actually lower rent, for something that supports property rights? Or are you going to vote against landlords, for a litigious society, for things that drive up the cost of rent, for things that drive people out of the market, which further drives up rent? It's really a simple amendment. Just a really simple amendment. Probably has ramifications across the board. You can actually do something to lower the cost of rent today. You won't, but you could. So I recommend that you vote for property rights, for the landlords who are out there trying to provide a good service for a good product, and actually help the economy of the state of Colorado instead of attacking it further. This is a great amendment. You're up.
Representative, nope, seeing no further discussion on the amendment. The question before this is the adoption of Amendment L17. Those in favor say aye. Aye. Those opposed, no. No. L17 is lost. To the bill, Representative Arbogast.
Thank you, Madam Chair. I still think there needs to be discussion on this. When we're talking about taking people that are in crisis and putting them in a position where they're still losing, we're not helping the people that are in crisis, the people that need the help, that are clearly struggling and suffering. The least we can do is help them with the cost of attorney fees, even if it is something that comes out of their reward money in a lawsuit. So with that, I move L020 and ask it to be properly displayed.
The amendment is properly before us. Please proceed.
Thank you, Madam Chair. So this takes a high-end approach. I think we went low-end. I'm not going to sit here and walk this up all day. The fact of the matter is, if we're not willing to simply say $25 an hour, average attorney fees per hour, I would say roughly $200. So if we're going to be charging for legal services for people that are in crisis, we should not be able to charge them, attorneys should not be able to charge them more than $200 an hour. I think this is more than fair. This still puts them in harm's way by keeping them from money that is rightfully theirs in these situations. We shouldn't be charging them more than $200 an hour. So that's what this amendment does, is puts a cap on attorney fees at $200 per hour. I ask for a yes vote. Thank you.
Any further discussion? Representative Mabry.
We urge a no vote.
Any further discussion on the amendment? Seeing none, the question before this is the adoption of Amendment L20. Those in favor say aye. Aye. Those opposed, no. Amendment L20 is lost. To the bill, Representative Wilson.
Thank you, Madam Chair. Now that the bill sponsor is back from being stepped out, I'm going to ask a question about Section 3812-1303, cause for eviction required, no fault evictions. There is cause, line 18 is there is cause for an eviction, and I'm specifically asking about 1 through 6 on page 8. Residential premises described in section 3812-1302, 1A or 1B. The part I'm specifically curious about is holdovers and continues in process of the property or premise or any portion of the property or premise after the expiration of the term for which the property or premise was leased or after the tenancy, at will or at sufferance or has been terminated by either party. Just need clarification on what exactly this is referring to and how it works.
Representative Mabry.
Can I see your copy? Can you just use your copy? Yeah. All right, thank you, Madam Chair. Thank you for the question. I actually think this is a great thing for us to dig into and to point out. So specifically what we're talking about is page 8 of the bill, line 1. It states that basically if there's a holdover tenancy and the tenancy is as defined in 3812-1302, 1A or 1B, then this process that we're trying to change for residential tenancies can continue. So I see why this is confusing, but 3812-1302, 1A and 1B are the exemptions. This is reflected in amendments that we've made. This says it doesn't apply to short-term rentals, mobile home parks, folks who we have worked with to make sure that we're not unintentionally covering people that aren't within the intent. Basically not traditional residential tenancies.
Representative Taggart.
Madam Chair, it's an honor to serve with you.
Honor to serve with you.
I'd like to move Amendment 21 to House Bill 1098 and ask that it be displayed.
The amendment is properly before us. Please proceed.
Thank you. This amendment is a very simple amendment, and it addresses something that many of us have had to do, and that is for our mothers-in-law that are disabled later in life, or one of our children that might be disabled, we may take over that premise and want to take over that premise, but as the bill reads today, my mother-in-law needs to be in there in 3 months, and it may take me longer to actually build out the premise for her disability or my father's disability. It really doesn't make a difference. So this amendment just gives the landlord a reasonable amount of time to make the changes to the premise for that disabled person. Thank you.
Representative Wilson.
Thank you, Madam Chair. Yes, I agree. This is a good amendment. This amendment also kind of ties in 2 portions of the bill. One portion being the right to have time to renovate a unit as a lease expires, but this also takes into consideration the ability to adjust that for a family member if there is a disability, and these things can come up fast. So I ask for an aye vote on this amendment.
Representative Mabry.
Thank you, Madam Chair. And I would like to thank my colleague from Grand Junction for raising this issue because I actually agree this is a really good idea. What we're doing is just clarifying here, if you're moving in an immediate family member and you need more time to accommodate their disability, you get a reasonable amount of time. So we think this is a good amendment and urge folks to vote yes.
Any further discussion on the amendment? Seeing none, the question before us is the passage of Amendment L21. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Amendment L21 passes. Is there any further discussion on House Bill 1098? Seeing none, the question before us is the passage of House Bill 1098. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it. House Bill 1098 passes. We're going to go into a brief recess. Committee will come back to order. Mr. Shebel, please read the title of House Bill 1122. Madam Majority Leader.
Thank you, Madam Chair. I move to rise, report progress, and beg to sit again.
You have heard the motion. Seeing no objection, the committee will rise and report progress and beg leave to sit again.
The House will come to order. Members, thank you for your patience this morning. We have just an unusual circumstance and wanted to make sure everyone understood. Because our Joint Budget Committee is very deep in their figure-setting process and they need to continue moving, we will be excusing our 3 Joint Budget Committee members today so that they can convene the Joint Budget Committee in about half an hour. The chair of the Joint Budget Committee will be communicating that shortly. So Representatives Byrd, Sirota, and Taggart will be excused at this time so that the Joint Budget Committee can meet. Representative Doherty. Members, you have heard the motion. And now, seeing no objection, Representative Doherty will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader. The coat rule is relaxed. Mr. Shebel, please read the title of House Bill 1122.
House Bill 1122 by Representatives Duran and Puglisi, also Senators Roberts and Winter F., concerning civil protection orders for victims of domestic-related crimes.
Majority Leader Duran.
Thank you, Madam Chair. I move House Bill 1122 and the Judiciary Committee report.
To the committee report. Majority Leader Duran.
Thank you, Madam Chair. In committee, we ran 3 amendments in response to some of our stakeholders, including Office of Parent Respondents, ACLU, and Judicial. L001 made sure that the current Brady notice language matches the federal language. This was the intent, so it is just a legal tweak to make sure it is interpreted that way. L002 narrowed the application of psychological or emotional harm to only if there is an actual threat as opposed to risk or threat. L003 made the implementation date to January 1st, 2025, and made other technical changes. There was also a conceptual amendment that removed the word perceived in front of threat. And I ask for a yes vote.
Minority Leader Puglisi.
Thank you, Madam Chair. It's an honor to serve with you.
Honor to serve with you.
Thank you. So I appreciate the Majority Leader coming to me with this bill. Last session, I told you a story about a friend of mine who was locked in a bathroom to escape her abusive husband, took her kids when she found it safe, and then he wound up going to court for a protection order against her in order to continue the abuse, coercion, and control. And so we've definitely made sure that there's some remedies for those survivors so that they don't become re-victimized again. And with that, I would ask for an aye vote. Thank you.
Any further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye. Those opposed, no. The ayes have it. The committee report passes. To the bill. Majority Leader Duran.
Thank you, Madam Chair. The contents of this bill is something that advocates for domestic violence and sexual assault have been working on for a few years. Violence Free Colorado, CICASA, and COVA have advocates who have helped survivors every day. Too many Coloradans live in fear of their safety each and every day. 1 in 7 experience relationship violence. Civil protection orders are a key tool used by survivors of intimate partner violence, sexual violence, and stalking to escape an abusive relationship. And I ask for a yes vote. Thank you.
Any further discussion? Okay, seeing none, the Representative Harrod.
Thank you, Madam Chair. And I just want to thank the bill sponsors, the Majority Leader and the Minority Leader, for bringing this bill forward. In committee, we talked a lot about protection orders, and I think that there is a conversation that needs to be had about abuse of protection orders in the system. Specifically, there were examples brought to us where protection orders were being used to control, to harass, to coerce. And the bill sponsors worked very diligently with me to ensure that we have a bill that does not allow the continued abuse of the system. Specifically, a lot of people assume that survivors are the petitioners in these cases. And as our Minority Leader noted, that is not always the case. There's many cases where the actual petitioner is the one who is petitioning to cause abuse, to gain control, and in some cases, to take advantage of the system in a way that could result in someone not even having access to their children. Not having access to their an attorney, quite frankly, to represent them in these very particular cases. And as someone who has gone through this process firsthand, and I know our bill sponsors have been very close to this process as well, I think there is a lot more work that needs to be done to ensure that protection orders are actually there to protect those who need that protection, not used to coerce, to bully, or intimidate. Thank you to the bill sponsors for taking an amazing step forward. I look forward to continuing to work with you on this issue. Thank you.
Representative DeGraff.
Thank you, Madam Chair. I'm curious, I know there was a move on this on page 519, and maybe I just don't have the right bill and missed it, that, okay, strike perceived. So I am a little concerned still that there's some of this that's already covered by the emergency protective order stuff that we have with red flag laws. I haven't had a chance to delve into it. My main thing was the perceived. In my rush to get down here, I didn't see that was done. That's in the green sheet, and that was adopted.
Any further discussion? Seeing none, the question before us is the passage of House Bill 1122. All those in favor say aye. Those opposed, no. The ayes have it. House Bill 1122 passes. Mr. Schiebel, please read the title of the House Bill 1041.
House Bill 1041 by Representatives Kipp and Taggart, also Senators Bridges and Van Winkle, concerning the streamlining of processes for filing sales and use tax returns.
Representative Kipp.
Thank you, Madam Chair. I move HB 24-1041 and the committee report.
I believe there are two committee reports.
The committee report, the appropriations and the Finance Committee report.
To the Appropriations Committee report.
Thank you. The Appropriations Committee appropriated some money to make this bill happen.
Any further discussion on the Appropriations Committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye. Those opposed, no. The ayes have it. The Appropriations Committee report passes. To the Finance Committee report. Representative Kipp.
Thank you. The Finance Committee made basically some technical amendments to make sure that this bill would move forward in a way that was agreeable to all parties.
Any further discussion on the Finance Committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The finance report passes. To the bill, Representative Kipp.
Thank you, members. This bill came from the Sales and Use Tax Simplification Task Force, which is an interim committee. That bill, that committee has been tasked with simplifying Colorado's overly complex sales and use tax structure. It's been in place for a number of years. Every year we bring forward a new set of bills that are bipartisan to try and improve the ease of making it easier to comply with sales and use taxes in Colorado. What this one does is it modifies the tax filing thresholds for any sales and use taxes collected by jurisdictions that don't use the SET system, and it also, so we're basically trying to, and it raises the thresholds for the state to make sure that people who have less money to remit don't have to file as frequently.
Any further discussion? Seeing none, the question before us is the passage of House Bill 1041. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. House Bill 1041 passes. Mr. Schiebel, please read the title of House Bill 1100.
House Bill 1100 by Representative Vigil, also Senator Hawkes Lewis, concerning a requirement that a coroner be certified by the American Board of Medico-Legal Death Investigators or the American Board of Forensic Pathologists.
Representative Vigil.
Thank you, Madam Chair. What a pleasure it is to serve with you.
Pleasure to serve with you.
I move House Bill 1100 and the Transportation, Housing, and Local Government Report.
To the committee report.
Thank you, Madam Chair. So friends, we made a couple of amendments on this bill in committee. All of them were supported by our core stakeholders. We had a little cleanup on the title to make sure that the board we were identifying that certifies forensic pathologists was accurately identified. We struck a bit of the bill that the association had asked us to add and then decided they didn't want that, so we went ahead and struck that from the bill. And also added an effective by date of November 5th, 2024, just to be clear that we're talking about for counties to which the bill will apply, that it does not apply to coroners who are currently in that office or create any kind of conflict for them if they're already sitting in it. And that's all that our few amendments did.
Any further discussion on the committee report? Seeing none, the question before us is the passage of the Transportation, Housing, and Local Government Committee report. All those in favor say aye. Those opposed, no. The committee report passes. To the bill, Representative Vigil.
Thank you, Madam Chair. Colleagues, I have kind of a neat, fun little bill for you today. It's kind of one of my favorites, actually, I've gotten to run this year. So for a little background on this, we do elect all of our coroners in our counties. We do have an educational requirement on it already. It is just very low. In order to serve as a coroner in any one of our counties right now, you need only be an adult non-felon with a high school diploma. And this might not be the worst thing in the world in some of our smaller counties where there is a class that you can take upon being elected. But in a lot of our larger counties where autopsies are referred from our smaller counties, it's really, really important that the person who takes that office is ready for it when they get to the job. And that they have the proper qualifications. So our bill will require that in order to hold the office in a county with 150,000 or more in population, that you at least be a certified death investigator with the American Board of Medical Legal Death Investigators, or that you be a forensic pathologist. This is a bill that came to me from my own community. My own coroner is very supportive. We've met extensively with the Coroners Association. They have come in a support position on the bill. Couple of disagreements will always exist, but on the whole, we feel really good about where we're at. Currently, just for a little bit of context for this, in case anyone is confused about where this comes from, the Colorado General Assembly holds the authority to set qualifications for the job of county coroner. That is Article 14, Section 8.7, if you want to check it. And we do this for other offices. You can't be a county surveyor right now if you aren't a licensed surveyor. You can't be a DA if you're not an attorney. There are some reasonable qualifications that we need to set for offices of a technical nature just to ensure that that service is well provided. And in counties like mine, I think this is especially important because we don't just serve El Paso County. El Paso County's coroner's office is the largest in the state. We provide autopsy services to over 20 other counties, much of southern Colorado. A number of my fine colleagues in this room, there's a very good chance that if a death needs to be investigated in your county, that there was a death in your county, it will be sent to the coroner's office in mine. And so I do think it's really important that the voters, that the electorate of El Paso County and other large counties, there's 11 in total that this bill covers, that they are choosing from a pool of candidates who can adequately serve everyone. While we do have a county coroner model for how we elect folks, the effect of how this plays out in practice is that we operate almost as if it is a regional medical examiner model, and some of our coroners do in fact operate that way. So I will just add for a little context so we remember what's at stake here, and then we'll see what other questions and discussion we have. Coroners' findings are a critical public service. There's a reason why we don't do this on the private market. It's a public service. This is essential for public health and safety findings. Criminal justice proceedings hang in the balance. And for most people, this is the only way they'll ever know what happened to their loved one. Surviving loved ones have a right to know what happened to the deceased. So doing this at a public level is really important. It's not a commodity, it's for the public good. That's why we do it that way. So we want to make sure that that service is actually robust and professional and that folks have everything they need. And with that, I would ask for your yes vote.
Representative Wilson.
Thank you, Madam Chair. I just want to start off with one question on the bill. In the bill, you have an safety clause, but then you also have in the amendment that this is not to be an act, or not to start till after the November 5th, 2024 election. There's 157 days between the petition clause and November 5th. So I'm just kind of curious why the bill sponsor would want a safety clause enacting it right away, but it says it's not, that the individual must be elected after November 5th, 2024. So just a question to start with.
Representative Vigil.
Thank you, Madam Chair, and thank you, Representative Wilson, for the question. I'm happy to look at changing the, let me look at that amendment a little bit more closely. Have you moved an amendment, or are we just asking? You haven't, okay. I'm happy to look at that and come back to it. Do you have further remarks?
Representative Wilson.
Thank you to the bill sponsors for working on clarifying that. Do want to discuss the bill a little. This bill, I feel like it's coming from kind of protection of coroners with certain degrees. The bill doesn't allow for even requirements. In all our counties, we require our sheriff to be post-certified within 1 year of election. In all our counties, we require the district attorney to have 5 years attorney practice. But this bill, we're going to say only these counties are required to have a coroner that is certified in these individual areas. And I think that's inappropriate. If we're going to do it, let's do it for everyone. Let's apply the law evenly. We also want to make sure that if we're going to require this, we do it for everyone. But the thing I ran into in committee is even those testifying in support already said that their staff was trained in this, that they were trained in these methods. So the training's already out there. Do we even need the law? If the training's available to everyone, whether you're rural, it might be a little more difficult in rural to get to the training. But the training is out there. The 11 counties that this applies to, only 2 individuals don't have the certification. They all managed to get it after they were elected or in some training. The other thing this does is it weaponizes the field. So if you have a new employee that wants to get this training and you feel that they might run against you in the next election because they're going to have the qualifications, you might decide not to hire him. You might say, hey, you need to go somewhere else and get your qualifications. You're not going to get it in my office. So there's a lot of concerns with this bill. I think we should start with just making it, since it's an investigative position, in the sense that it requires, one of the requirements is, or one of the options for the requirements is being a death investigator. I think we should do it just like the Sheriff's Department. The Sheriff's Department leads investigations. So with that, I'd like to offer Amendment L005. Or I move Amendment L005 and ask that it be properly displayed.
That has been properly displayed. Please proceed.
Thank you. This amendment would just say, hey, just like the sheriff has to get his post certification within his first year of being elected. This would say the same thing. You need to get your death investigator or your pathology within the first year of being elected. So I would ask for your aye vote on this amendment, and let's make it the same across the board.
Representative Vigil.
Thank you, Madam Chair, and thank you, Representative Wilson, for your attention on the bill and for making suggestions. I'm nonetheless going to ask for a no vote on this amendment. I'll tell you why. We did extensive conversations among coroners and a variety of populations about how the timeline needed to work here. There's absolutely nothing wrong in some cases with getting that certification after being elected. If that's something that is of a concern in sheriff's offices, that sounds like that would maybe be a different bill someone would want to run. It's not within the context of this bill. There is I think the distinguishing characteristic here is that you might need to be doing death investigations the day you hit the office in a large county, and you would not need to be doing that in a smaller county. So this was always been the reason why there was a difference between larger population and smaller population. And to quote my own coroner, hoping that no one will die for the first year that you're in office is not a good strategy. So I'll ask for a no vote on this amendment, please.
Representative DeGraff.
Thank you, Madam Chair. I support this amendment. I am familiar with the discussions around this because it is from my same community, same coroner, and around some of the duties of the coroner. And we have three in this field. I guess we have three different places. We have the medical examiner who's elected, we have the coroner who's elected, and we have the sheriff who's elected. So they're all independently elected, and so they all serve as checks and balances on each other. So I would propose that the best way to ensure that the coroner has the appropriate level of qualifications across the field to work with not only the coroner but the medical examiner, the sheriff and the medical examiner, and to counter them where needed, that the people of these counties can actually make this decision. There is a reason, and if you look at and if you regard somebody like C.K. Chesterton, who observed that if you come across a fence in a road, you don't just remove it because you don't think it needs to be there. You need to go back and you need to figure out why it was there, and then maybe think about removing it. But first you need to really understand why it's there. And the reason for the coroner is not necessarily to do autopsies. Autopsies are quite often, I would question how many autopsies the coroner actually does, because the primary goal, the reason of that is not autopsies. That can be outsourced. The purpose of the coroner is to provide balance against the sheriff and the medical examiner. And so I would say, well, this is a nice to have. It is not a need to have, and it's certainly not a necessary to have, especially if you say bring on a trained doctor who's trained in doing an autopsy and they can get this certification. This is a better field for the voters of Colorado to make a determination, because they need to weigh all of the duties of the coroner, not just a very specific few, and certainly not a very specific few that can be outsourced. So I recommend an aye vote on this amendment, because certainly it's a good thing to have, but it is just a small increase from what a medical doctor has. And certainly when the coroner's position was established, we knew what was going to have to be. Now, perhaps a high school diploma doesn't mean what it used to mean, but that's another problem for another day. But the coroner has much broader responsibilities than just this certification. And to limit your coroner to this certification is really more of a Jobs Protection Act than it is a service to the community. So I support the amendment. I support having this, but there's certainly a lot more important things like the leadership, the constitutional awareness, the willingness to counter. If you put this in, what you're actually doing is you're much further limiting the pool of candidates. And that's why I would consider it a Job Protection Act. Because otherwise you have to have people go out and get the certification that they don't need, where otherwise they could do a just-in-time certification to get it when they do need it. It's already there. The system is in place for them to get the certification that they need. But they don't even need it, a certification that would be desired. So if the goal is to have more access to more candidates, this bill overall, without this amendment, is actually limiting your pool. And you're going to have a harder time getting a pool of candidates because they might not want to go and get this certification without having the job, or they might not even be able to get the certification without having the job. This certification is designed for people that get the job and then need the certification. So once again, I think overall, without this, the bill is actually going to make your problem worse. It's not a surprise, but it'll make your problem worse.
Representative Vigil.
Thank you, Madam Chair, and thank you for the good dialogue on this. With all due respect to my colleague from El Paso County, I can't imagine how you'd be familiar with the discussions. He was not in any of them. This was a discussion I had with multiple coroners around our state. So happy to clue you in on the conversations we did have if you're interested. This bill does create some checks and balances. So in our smaller counties where these death investigations are not done at the autopsy level, they are dependent upon facilities in larger counties. They're being referred to counties like ours in order for that to be taken care of. We'll cover this again, multiple offices of a technical nature have some sort of professional requirement to run for the office. Yes, it limits the pool to certain people who are qualified to hold that office, but that is the nature of these things. And so I will ask for a no vote on this amendment, please.
Representative DeGraff.
Thank you, Madam Chair, and I am extensively aware of this conversation because it was an extensive conversation prior to the last election. That's where this bill stems from. This was an extensive conversation because there was another doctor, a fully qualified doctor, that was running for the position against a coroner/medical examiner who is holding down both positions, and this bill would protect and limit the field to one person to further justify one person holding down two full-time jobs. Now, if you're wondering how one person holds two full-time jobs, the county of El Paso County was also curious about that. And we've gone through the qualifications and the requirements of the coroner extensively. What is required? Why is it required? And then what this bill does is it goes in and it specifically carves out a niche for an individual to limit the qualifications to be that person. So yes, I am very familiar with this case. I have been involved in it. Strangely, I was not brought into this conversation since it does apparently affect my county. So, but no, I disagree wholeheartedly that I am very familiar with this case, and I would suggest that I'm more familiar with the case and the origins of this case than the sponsor. So what this is a bill that is designed to protect an individual's employment, and it will have the broader effect of limiting the pool of candidates that you have for coroner, because you're limiting it to a requirement that can be gotten afterwards. The voters of Colorado can weigh the duties and responsibility of the coroner in relation to the medical examiner and the sheriff and the rest of the government, and they can make a determination. And if there is a autopsy that needs to be done, those autopsies are done on a regular basis by outside of the coroner's office. The coroner is not the only person who does autopsies. The coroner has much broader responsibilities, and this bill limits the coroner's responsibilities for a very narrow field. It is a job protection bill for an individual. I recommend an aye vote on this because it takes that away. It takes that very focused protection away, and it allows the field to open up. Again, if the bill is designed to provide more opportunities for coroners, there's a very interesting specific limit on the population. This is a very specifically designed bill. I recommend an aye vote. I recommend that this body open up the aperture to be able to fill these bodies, to fill these coroner positions, and allow the voters of Colorado. What this bill does is it assumes that Colorado voters cannot weigh the pros and cons of different qualifications. And it limits the pool intentionally. Again, this is a jobs protection bill. And I recommend a no vote on the bill, but I at least recommend an aye vote on this. If you want to make the problem worse, vote for this bill.
It's getting a little bit loud, so members, can we take it down a notch? Representative Ehill.
Thank you, Madam Chair, and I fear we veered quite a ways off of the amendment on the last remarks. I just want to come back to what the amendment says and be clear about why I recommend a no vote on it. The amendment L005 that we're on would move the obligation to fulfill those certification requirements from before you could run for office, because you would not be able to hold the office with this statute in place, and allows it to be completed afterward. And that is not sufficient for our purposes, and again, I'll say why. This is not to protect anyone's job. This is to protect public health and safety, necessary evidence for criminal justice proceedings, and to ensure that this continues to be a critical public service that covers everyone's needs. Again, we'll say again that putting education requirements on an office is within bounds. The state constitution explicitly tells us that we can, and it is very wide open. I'll go ahead and pull it up again. We'll quote it for you. Let's find it. Article 14, Section 8.7, the General Assembly shall have the authority to establish by law qualifications for the office of county coroner, including but not limited to training and certification requirements. That is what we're doing with this bill. We can set those requirements. We don't have to say that it's after the office. We might do that for some other offices. We're not touching that in this bill. But if we don't want someone who's not an attorney to become DA, we don't allow someone who's not a licensed surveyor to become surveyor. Frankly, it seems like this has gone on long enough that we haven't put this safeguard in place. It will apply to most coroners who are already in these large counties. We've been over that. There are a couple to whom it does not apply. Both of those coroners are in support of this bill. They agree that that certification is important. That's why they're getting it as quickly as they can. And they support our efforts to ensure that all of those large counties are moving at the same pace and provide these services for everyone. I do want to correct one thing that was just incorrect about what was said by the last member. Coroner's offices do in fact do autopsies. The coroner themselves might not necessarily continue to do every autopsy. Said he wasn't sure how many. I know in El Paso County it's by the hundreds every year, not just for ourselves, but for many other counties. And I can pull up that data if my colleague would like to see it. They do determine cause and manner of death. That is their responsibility. Just because the person who is elected coroner, who runs that office, is not presently doing every single autopsy, or maybe goes hands off at some point, which is acceptable, it is important that that person has done them, is aware of how they're supposed to be done, does know when to check off on someone's work. It's very important that they have the capacity to do that. And I will say this is a little bit preemptive out of concern that somebody could come into one of these offices who is not qualified for it, has some kind of other agenda in mind, and would not be effective at the public health and safety and criminal justice needs that the determinations of coroners provide. It's very important that that quality stay high. The Constitution gives us clear authority to do so, and I ask for a no vote on this amendment.
Representative DeGraff.
Thank you, Madam Chair. I think an important thing to mention and note in the Constitution is that can does not equal should. Can is the ability to, should is something that you are compelled to do, something that you should do. Now, when our Constitution was established and these jobs were established, there was a very limited scope. And you could say, yeah, that is a very limited scope for coroner. And there's a reason for having a very limited scope for coroners, because there's a broad range of duties. And like my colleague said, that whoever's doing the coroner should have the capacity. Now, a doctor, a medical doctor, a trained medical doctor, probably has been trained in doing autopsies, certainly done, if they're a medical doctor, they have the ability. And as my colleague said, the coroner does not necessarily do the autopsy. So the coroner oversees the office of the coroner. And there are lots of times where the person who oversees the office does not actually do, or maybe has not actually done. I'll refer to a colleague who ran a company that built watches. I'm going to guess he never built a watch. That doesn't make him unqualified to run the company. A coroner has the ability to get the training, has the ability to oversee the office of the coroner. That's what a coroner does. A coroner oversees the office of the coroner and stands juxtaposed to the medical examiner and the sheriff in the county, independently elected positions. My colleague noted that there are several coroners that are getting the certification, and they agree that the certification is necessary. But I don't think they're quitting their job, and I don't think they're going to say that they couldn't do it. This bill is going to make your problem worse. You're saying we have to have this certification over over everything else that the coroner needs to do. You're saying that this certification that a person can get after they're elected is more important than their leadership capacity. And you're limiting the field of the people that can do the job. So yeah, maybe it isn't important to get that capacity. That would be something better for the counties to determine. And I would say yes. My colleague spoke about somebody becoming elected to fulfill an agenda. What about limiting the field to support an agenda? There are motivations behind this bill. The motivations behind this bill are not to have full aperture for all the candidates who need to be considered by the voters of Colorado. The agenda behind this bill is to limit the field. It's to intentionally limit the
And
field.
Representative DeGraff, I'm going to just suggest that maybe a way to make that remark to the body would be to simply say the intent of the bill or the outcome of the bill as opposed to the agenda of a particular member or the bill. So making the same argument, just keeping it away from the member's intent or something along those lines.
Thank you, Mr. Chair. I do appreciate that. I agree that it is I think it's not only a better and more polite way to say it, I think it's a more accurate way to say it. So I do appreciate that. The outcome of this bill will be to limit the people who can run for coroner's office. That's what this bill does. It limits the field of people who run for the coroner's office. This right here allows this body. There's a lot of things this body can do, but should not, but does anyways. This bill, the outcome is to limit, or the outcome will be to limit the number of people who are eligible to run for the coroner's office. It will limit that. It will limit the number of people that can become coroners. It will degrade the service to the people of Colorado by limiting the field for a certification that can be had after the election. Because in the meantime, the leadership of the coroner is much more important. As my colleague emphasized, the coroner does not necessarily do these autopsies. The coroner oversees the office that does the autopsies. If you want to make the problem worse, this is your bill.
Further discussion on the amendment. Seeing none, the question before us is the adoption of Amendment L5 to House Bill 1100. All those in favor say aye. Aye. All those opposed, no.
No!
The amendment is lost. Back to the bill. Representative Wilson.
Go ahead, Chair.
Thank you, Mr. Chair. I'd like to offer I move amendment L004 and ask that it properly be displayed.
1 second. We'll get that amendment before us. The amendment is before us. Please proceed.
Thank you, Mr. Chair. This amendment just goes to my earlier question. It seemed a little wonky to have a safety clause on the bill and at the same time have a not taking effect date till after the next election, which allows over 100 days difference there for the bill to take effect. That change was, the original change to November 5th, 2024 was in the Transportation Local Government Committee meeting of 001. So I ask for an aye vote on this amendment.
Representative Vigil.
Thank you, Mr. Chair, and thank you to my colleague from El Paso County for bringing the amendment. It works for me. It's a friendly amendment. Please vote yes.
Further discussion on the amendment, L4. Seeing none, the question before us is the adoption of Amendment L4 to House Bill 1100. All those in favor say aye. Aye. All those opposed, no. The amendment is adopted. Back to the bill. Any further discussion? Representative Vigil.
Thank you, Mr. Chair, and I'll just thank everyone for your attention on this issue. It's very important for public health and safety, as I said. We want to get this right. I do just want to note one thing so that it's on the record and we're clear about it. Our Constitution was ratified with this coroner's model in 1876. Literally, the germ theory of disease was still up in the air in 1876. We had a president die of infection from a gunshot wound 5 years later because his doctor didn't believe in the new theory yet. I think we've come a long ways. We need to embrace the new science. Please vote yes.
Representative Soper.
Thank you, Mr. Chair, and it's an honor to serve with you.
Honor to serve with you, sir.
I rise in opposition of this bill. And it's not that I don't want to see coroners have a higher level of education. I mean, as the bill clearly says, for a county of 150,000 or greater, they either be a certified death investigator or medical legal death investigator or forensic pathologist. What I don't like is this bill creates two different Colorados. What I just read was for counties of over 150,000. But if you're under 150,000, you'd be exempt. So I represent two counties. One is Mesa County, closer to 170,000, so they would fall under the 150,000 threshold. The other is Delta County, which is 30,000 people. They obviously would fall under, let's call it the exemption. Two counties next door to each other, two different standards in law. And yet, across the board, we have the Office of County Coroner that we should be accepting and expecting the same standards for. We shouldn't be saying we want a higher level of education because you're a big county in Colorado, and then at the same time telling rural counties that your coroners can have a lower level of education. That is, well, quite frankly, that's quite insulting to rural Colorado, to say that we're not smart enough, we're not good enough, we don't have the same quality of people. But by the same token, a coroner is also the only county official that can arrest the county sheriff. So this person possesses a large amount of power outside of just death investigations. And oftentimes, those get delegated out. Certainly in larger counties, you don't actually have the county coroner doing the death investigation work. That actually could be someone else in the office. So it greatly limits the pool of people who would be able to run for the Office of County Coroner within these offices. For example, in Mesa County, that would be one person. Well, right now, there's still term limits for the county coroner, which means that we're on a path of our county coroner will be termed out, and yet he's the only one that possesses the credentials that are required for a county of over 150,000. So after him, do we just cross our fingers and say, we hope that the next person after term limits kicks in will meet these qualifications? Because we also still have residency requirements. We still have that you have to have lived in the county for over a year prior to the election. So there's many problems that starts to kick in that are not just tied to the education level that we're expecting of our county coroners, which is why it was a real shame that the amendment that was offered earlier was not accepted. Because being able to have the ability to become licensed or certified according to the American Medical Board of Death Investigators or the American Board of Pathology be allowed, rather than having this gateway before you can even run for the job. Even looking at other county offices, did you know that the county sheriff has 1 year to become post-certified after winning the county sheriff's election? So anyone could run for county sheriff, but yet the sheriff has 1 year to become post-certified. That should be also the same for county coroners. We ought to at least have time for anyone to run and then go ahead and become certified. And if they're not going to become certified, then we'll just have another election. We'll bring someone else in. We already do it for sheriffs. Why not for coroners? I would urge a no vote unless amended. Thank you.
Further discussion, Representative DeGraff.
It is very disappointing that the amendment didn't pass because now we have an all or nothing. You could have had a broader field with, say, medical professionals who are absolutely 100% qualified to do this job, just missing a certain certification. Because the next thing that's going to come back up is that, well, if we can protect one job with this, then we can protect the sheriff job with post-certification that you have to have prior to. And then we can protect somebody else's job by requiring it, because we'll have set the precedent on how we meddle in the county's elections. Now, I'm pretty sure the way this is supposed to work is that we're supposed to be supporting the counties as opposed to dictating to the counties. The counties can make their own determination. Now we have, because we have this all or nothing, we could have said, hey, we should have this for all the county coroners. But now it's a must. And now we have this differential. And now we're saying that this is the main qualification of a coroner. There's lots of other reasons to elect a coroner. Not just a very narrowly focused training that any medical professional can get. There is no problem that the government can't make worse with a solution. This solution makes the problem worse. It absolutely makes the problem worse. The outcome of this bill will be to limit the available pool of coroners to a very specific certification that can easily be gotten by somebody after election. We haven't even covered why this is so important. Because I don't think this pathology, I don't think this actually trains somebody in doing an autopsy, because they've already had that training. Absolute 100% guarantee that this bill will make your problem worse. I recommend a no vote on this bill.
Further discussion on House Bill 1100. Seeing none, the question before us is the adoption of House Bill 1100 as amended. All those in favor say aye. Aye. Opposed, no. The bill is adopted. Mr. Schiebel, please read the title to House Bill 24-1076.
House Bill 1076 by Representatives Marshall and Weissman, also Senator Fields, concerning creating a program to recognize public schools that provide certain services to military-connected families.
Representative Weissman.
Thank you, Mr. Chair. We move House Bill 1076 in the Appropriations Report.
Thank you, sir. To the Appropriations Report.
In the Appropriations Committee this morning, we appropriated about $30,000 for 0.3 of an FTE to implement the program. We ask for your support.
Further discussion on the committee report. Seeing none, the question before us is the adoption of the Appropriations Report to House Bill 1076. All those in favor say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill, Representative Marshall.
Colleagues, I move House Bill 24-1076 with the committee reports.
You are good to go, sir. To the bill.
Colleagues, this is a very little niche bill, but a very important one for the people that it impacts. 42 states have this Purple Star program, which is to help DoD children integrate better into the public schools, or any schools really, but mainly the public schools. 42 states, yet Colorado, we have the 10th highest per capita number of active duty military members, and we don't have this program. So I was asked to help run it, even though I don't have a very large active duty population in my own district. But when I did, I found out Douglas County actually has quite a lot of bleed over from Buckley Space Force Base to its north, and quite a lot of bleed over from El Paso County from the bases down there. And our school district was very excited about it, thought there was definitely something that was needed here. And I had no idea how popular this bill actually would be when we got to the committee hearing. Very important bill for the people it impacts. These military kids move around, and colloquially, as we call them, military brats. It'd be a very helpful first step, and I ask for your support.
Representative Weissman.
Thank you, Mr. Chair. Members, as noted, we are quite an outlier in not already having codified some version of the Purple Star program. This is an effort, a badge, if you will, that military families who do move around on a regular basis on orders are familiar with around the country. Purple Star status for a school is something that a military family will look for. We heard that from folks who've lived it. We lack that right now. We have roughly 44,000 military-connected students out of our, verging on 900,000 in Colorado. It's rather a lot. This is important to my district in particular. It's why I appreciate being on the bill with Rep. Marshall. My district contains Buckley Space Force Base. There are 1,000 folks resident. The total number reporting for work there every day is about 15,000. That's a measure of the number of families connected. my school district supports. And although the issue of supporting military-connected families is not a strange thing for Aurora Public Schools, we heard from the superintendent that even so, this program would help take things up a level in terms of formalization and visibility. It really was a bit of a love fest in committee, and we think for understandable reasons, we ask your support to join the great majority of states in Purple Star status in recognition of and support for our military families and their students. Thanks.
Further discussion on House Bill 1076. Representative DeGraff.
Thank you, Mr. Chair. As a father of 3 military brats, I'm going to vote no on this. And I'll say that we've had this problem with moving around with schools. I think we moved around 20 different times. And yeah, it's a problem. But if a good intention was a good idea, it wouldn't need a gun. Now you have a good intention, perhaps. There are parts of this bill where now you've opened it up to certification and all that, but ultimately this bill is voluntary. So the schools are saying, with this certification, that we are going to take this certification on voluntarily, which they could do voluntarily and receive that certification or receive that recognition. Because this plays well in the free market. And this is a great example of the free market. A free market is a place where you exchange good for good. And if this is good, something good, then the military families will be encouraged to go to that school. If they're encouraged to go to that school, the school's population increases, the school has more budget. So the schools are already incentivized to do this, especially in areas that have a high military community. Because the schools, the counties that surround it, that are in the areas of these military facilities, have every incentive to go to these schools and say, hey, why don't you do this voluntarily? And those standards can be put out there. The standards are out there. What needs to be done voluntarily? But here's something, we don't need to put voluntary things into the law. So what is it in here in this voluntary purple, and my kids actually all participated in Operation Purple, and were participated around the country in Operation Purple. So I'm very familiar with a lot of these things, and I'm very sympathetic to the cause of the military parents, but I'm not sympathetic to inserting the government where the government doesn't need to be. This is just a place the government doesn't need to be. It says it's voluntary. Well, what happens with a voluntary program? A voluntary program becomes mandatory because good intentions go that way. So yeah, I've had the challenge. Part of the challenge is when you move to a new school halfway through high school, and the requirement for state history is a freshman level class, and you're in Michigan one time when they're a freshman, it's Michigan history, and then you move to Colorado and they're a junior, and then all of a sudden they have to take freshman level. But they can do that voluntarily. This bill does not change the voluntary part. The counties have the incentive, the schools have the incentive to provide good for good. I don't see how this helps that. So I recommend a no vote on this bill. I recommend a yes vote. I recommend a yes from all these counties with all the schools, that they would look at these requirements, or they would look at these desires of these needs of the military family and adopt them voluntarily, just like this bill would have them do. But I recommend that this body not interject itself where it doesn't need to. This is an area, if these schools are all saying it's a good idea, then let them implement it. Because I guarantee to these schools that think it's a good idea that there's going to be teeth with this bill later on. So as the father of 3 brats, they'll appreciate hearing that at some point, I'm sure, I recommend a no vote on the bill. And I will happily explain why to all of the military families. Because again, this is a voluntary program. It's a voluntary program. A voluntary program does not need to be enacted by this body, and this body will, what goes into the law is eventually going to have teeth. I don't know what teeth. It'll have something to do with certification. It'll have something to do with control. And that is something that the military families are actually rejecting wholeheartedly. So I think it's actually in favor of the military community to vote no.
Representative Martinez.
Thank you, Mr. Chair, and it's an honor to serve with you.
An honor to serve with you, sir.
All right, we heard this in Education Committee, and I, like many others, was shocked that this has not happened at all yet here in Colorado. Seeing this and hearing what good this program is going to do to be able to help out our military families, to be able to help out the kids, make that adjustment, and really putting the resources that are going to be necessary for them to, be successful in their education, I think is really critical. I think one thing that I want to point out in this is that this is also pointed out in Education Committee. There are 42 other states that have already implemented this policy and that are doing right by our kids. And I was just, again, shocked that this has not happened here in Colorado. We have all these military bases. We have all of these kids. So we're looking at around 44,000 children of military members that are going to be affected by this. And I think that this is really the right move to making sure that we're taking care of them and showing Colorado, those that are stationed here in Colorado, that we really care and support them and their families, and making sure that they're not slipping through the cracks. I adamantly agree that this is necessary today. This is 44,000 students, so over 1,000 schools that are going to be affected here. And we will hopefully, once this gets through, be the 43rd state to do this, and hopefully see all 50 states adopt this policy shortly. So I am an absolute supporter of House Bill 24-1076, and I urge an aye vote.
Representative Holtorf.
Thank you, Mr. Chair. As the chair of the Veterans Caucus, we want to do everything we can to support our military families. Now, military families have a unique situation because arguably every 3 to 5 years they have to move in their lives. In some cases, it's even 2 years, 2, 3, 4, 5 years. Those military families are moving across the country, or they're even moving across oceans into Department of Defense, DOD schools. But when they come back to CONUS, continental United States, they have to enroll those kids in these schools. Not every kid goes to a DOD school. Many of them are living on the community, in those communities that are around the military bases. And this particular bill allows those families to identify those schools that have asked to and have enrolled in become a part of the program through the Purple Star School program. Now, I will tell you, the fiscal note is minimal. And the fact that families can identify with these military family-friendly schools is a very significant benefit to these families. I want to thank the bill sponsor. I want to thank a fellow member of the Veterans Caucus. I want to thank both bill sponsors. I want to thank Representative Weissman as well, because he has a very large military base with the U.S. Space Force. And that particular base is growing. That capacity is growing. If you listen to recent news today, there was an announcement that, and I don't want to get, I appreciate your leadership, Chair, so I'm going to see where this goes. But there was an announcement that now there's anti-satellite kinetic technology that's out there that's being developed by adversaries. So we need to support these families because we need the members that are a part of this U.S. Space Force. And if the family's happy, we always said this in the military, if mama's happy and the kids are happy, then everybody's happy. And this helps keep happiness with our military families. And arguably, these military missions and these service members, both male and female, have very challenging jobs. And they need to know that their family and their spouses and their kids are okay. So I'm 100% in support of this legislation as the chair of the Veterans Caucus. Thank you.
Representative DeGraff.
Well, I guess it'll be a veteran caucus of one. Number 43 out of 50, 44,000 students, 1,000 schools. That, to me, kind of tells me when the teeth will come in. We would be number 43. Probably the teeth aren't going to come until there's closer to 50. I don't know what those teeth will be. If this supported military schools, and I think I moved close to 20 times. We've moved our kids. They've been in school in Canada, Germany, Michigan, New Mexico, Oklahoma. We've seen the issues with this. This is a voluntary program. Yes, schools dealing with this, that would be awesome. The schools can already deal with this, and they can voluntarily, just like they will be able to after this bill, they will be able to voluntarily align with these Operation Purple requirements. Voluntarily. Because the schools that align voluntarily are going to be schools that families desire. And schools that families desire are going to be more, families are going to look at Colorado and go, I can continue my kids' schooling in Colorado. That's a draw. Schools have every incentive to self-enroll and self-identify with this Operation Purple. And I support that. I don't support the government getting involved in it because it doesn't need to. If it did, if it was mandatory, if it was absolutely essential and the only way forward on this bill, then maybe. If it was absolutely essential and the only way forward was for this body to act and make a requirement, then I would consider it. But it is not. It is a voluntary program. It is already being accomplished. It is the schools, as the sponsors have said, are already incentivized to do it. If the schools can voluntarily do it, the schools think that they should do it. I would just suggest that the schools actually do it. There's really very little beyond just changing a few requirements on graduation requirements. You modify a few graduation requirements, done. We don't need a law and interjecting the General Assembly to screw things up. That's all.
Further discussion on House Bill 1076. Seeing none, the question before us is the adoption of House Bill 1076. All those in favor say aye. Aye. Opposed, no? No. The bill passes. Mr. Schiebel, please read the title to House Bill 24-1053.
Go ahead.
House Bill 1053 by Representatives Weissman and Marshall, also Senators Liston and Hansen, concerning analysis of tax policy by the state legislative branch and in connection therewith, modifying requirements for evaluating state tax expenditures, requiring the state auditor to prepare an annual report on federal tax law and changes that have significant impact on the state's tax base, and extending the Legislative Oversight Committee concerning tax policy and the task force concerning tax policy.
With a title like that, it's a Weissman bill. Here we go. Representative Weissman.
Thank you, Mr. Chair. We move House Bill 1053, no committee reports.
To the bill.
And sorry about that one, Mr. Schiebel. Members, as noted, this bill comes to you from the Legislative Oversight Committee on Tax Policy. It was a 6-member interim committee. You'll see all 6 member names on the front. A little bit of context is that this particular interim committee met for its third year last interim, and the work done by our nonpartisan staff at the Office of the State Auditor has now essentially run one full cycle. Every tax expenditure on the books, save the latest ones that we have done, has been reviewed. So really what this bill is trying to do is look ahead and to make better and more efficient use of the capacity of our nonpartisan staff to best inform the General Assembly's deliberations about tax policy, particularly how that relates to issues that may emerge from federal law changes. This was unanimously supported out of the interim committee and the other day. We think it's just a good government measure, and we ask for your support.
Further discussion? Seeing none, the question before us is the adoption of House Bill 1053. All those in favor say aye.
Aye.
Opposed, no. The bill is adopted. Mr. Schiebel, please read the title to Senate Bill 24029.
Senate Bill 29 by Senators Gonzalez and Rodriguez, also Representative Amabile, concerning a study of how to measure the effectiveness of the criminal justice system using metrics other than recidivism.
Representative Amabile.
Thank you, Mr. Chair. I would like to move Senate Bill 29. Thank you. So this bill came out of an interim committee that is looking at recidivism. We ran 3 bills. One was looking at the definition of recidivism. Another one is looking at data. And this one is looking at other things that we should study that aren't recidivism but have to do with what happens when somebody's released from DOC or from a jail. And so we're trying to look at what are the positive things that can happen to somebody as they leave incarceration and they enter into a program. So did they get a job? Did they get reunited with their family? Did they get treatment? Did they get housing? And I ask for a yes vote.
Is there any further discussion on Senate Bill 29? Seeing none, the question before us is the passage of Senate Bill 29. All those in favor say aye. Those opposed, no. The ayes have it. Senate Bill 29 passes. Mr. Schiebel, please read the title of the House Bill 1258.
House Bill 1258 by Representatives Brown and Basenecker, concerning credit for the out-of-pocket expenses paid by a covered person when a health insurance carrier exits the market.
Representative Brown.
Thank you, Madam Chair. I move House Bill 1258 and the committee report.
To the committee report.
Thank you, Madam Chair. We had a robust discussion in Health and Human Services. We offered 2 different amendments which helped to deal with some of the challenges that were identified by the industry as well as consumers, and we would ask for your aye vote on the committee report.
Any further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report passes. To the bill. Representative Basenecker.
Thank you, Madam Chair. This bill really came out as a result of some work during the interim in response to the closure, or really the bankruptcy, of the Friday Health Plan. That put 30,000 consumers in the state of Colorado at risk and in an immediate need to find new health insurance, and also in some instances having to pay twice for services they've only received once. We are grateful for Denver Health and Kaiser for Permanente for reaching agreements with the Division of Insurance to honor the payments Friday consumers had accumulated at that time towards their deductibles and out-of-pocket maximums. This bill sets up a process whereby, God forbid that should happen again in our state, consumers are protected, they won't have to pay twice for services, and insurers can receive fair compensation for those services on behalf of the estate, or being able to schedule out those costs throughout a predictable schedule for consumers. So we'd ask for your support.
Representative Brown.
Thank you very much, Madam Chair. You know, in my district and across the state, many health insurance plans have deductibles that exceed $8,000, and they may have an out-of-pocket maximum that is nearly $10,000. Patients with chronic conditions or serious illnesses like MS, cancer, or hemophilia often hit their deductibles within the first month or 2 of a given year. When a health insurance company goes out of business, as Friday Health did last summer, this can put a large financial burden on Colorado families. 30,000 patients were faced with that this summer, and they not only had to look for new health insurance, but they had to face paying their deductible over again. So to that end, this bill, 1258, is really simple. When an insurance company goes out of business and a person enrolls with a new company, the new company has to give credit for the amounts that the person has paid towards the deductible and the out-of-pocket maximum on the old plan. It helps to protect consumers, and it allows the Division of Insurance to create a process so that consumers see this as seamless and, quite frankly, invisible. Representative Basenecker and I really believe that no person should suffer just because their insurance company goes out of business. I really want to thank him for his leadership over the summer in helping to lead efforts to encourage insurers to do this, and I really appreciate his partnership in this bill. We would ask for an aye vote to help protect consumers from unexpected additional costs.
Any further discussion? Representative DeGraff.
All right, so to protect customers from the event that their insurer goes out of business, the outcome of this bill will be to force other insurers out of business, because ultimately, when all of those have to come across because an insurer goes out of business, they come over, the incentive for the new insurer to take on that cost, to take on that individual, is going to be markedly lower because of this. So these insurers are going out of business for lots of reasons. This doesn't address why the insurers are going out of business. This isn't addressing why the General Assembly is driving insurers out of business or why the executive is driving insurers out of business, largely by the influx of immigrants unprotected by documentation. We have a crisis. And instead of dealing with the crisis, what we do is we put it on somebody else's back and say, all right, you insurers, and I'm not in favor of the insurers, don't get me wrong, I'm not in favor of the insurers. But what the outcome of this bill will be to drive more insurers out of business. Those patients will go on to somebody else. They will have no incentive. We see this with insurance like for fire insurance. The government has created a problem with improper forestry management. We've gotten bigger fires. We've gotten a problem. And so then we say, well, you have to insure. And then those insurers go, well, we can't make a go of it in Colorado, so we'll leave. So the insurers that are in Colorado, and they're limited in Colorado because we have these barriers around where people can operate, like TRICARE East, West, North, and South. So we're going to drive more companies out of business. Now, why are insurers required? Well, the insurers are required because Medicare pays about 20%. We're not going to deal with that. Because Medicare pays at 20%, only about 20%, that means only 20% of the patients, that's the only load that a medical facility can have before it has to jack up their prices by about 500%. When they jack up their prices by 500% to meet the demand of Medicare, then people are required to get insurance. And people are required to get insurance. Why? Because government intervention in the market has fouled it up beyond anything recognizable. So again, we're not going to deal with the problem. We're just going to, you are just going to feel good about pushing that problem onto somebody else without looking at the obvious ramifications. Now, insurance companies are involved in insurance. They're involved in insurance, in an exchange of good for good. Now, the good for the customer is the ability to negotiate the price that they would pay down to what Medicare pays. And then they'll have a 20% copay, which is effectively what they would have paid if it weren't for Medicare causing the prices to be jacked up. We're not going to deal with that. So because of the predatory pricing of Medicare, then we have to have insurers, and insurers are in this for a profit. And then you make sure, and then a bill like this comes along and says, we're not going to allow you to be profitable. So what do you think an insurance company is going to do when it's not allowed to be profitable? It's going to go away. And what's going to happen to all those patients who have already paid their deductible or at least part of it? They're going to roll over. So the outcome of this is going to be to get rid of insurers. And now, I can't speak to that intent, but when the outcome is obvious, the intent is inferred. It's just the way it is. This outcome will be to drive other insurance companies out. And again, there is no problem that the government can't make worse with a solution. We have a problem, we have a solution, you're going to make the problem worse. It's just pure math. Is that going to change anything? No. You're going to vote for it anyways. It's going to make the problem worse. I recommend a no on this vote. I recommend actually getting into the nitnoid as to why medical costs are high. And it's not hard to figure out. It's the forced government intervention into the marketplace. It is fouled up beyond anything recognizable. I would recommend not making this worse. Now, do I want these people to have to pay a deductible twice? Absolutely not. I think that's a horrible situation to put them in. This is not going to solve that problem. It's a temporary, it's going to feel good, it's going to make the problem worse, and then the solution will be more government requirements, because what you're doing is you're compelling these people to work in Colorado. If you're going to work, we're going to compel you to bear the cost of the legislation that comes out of the General Assembly. It would be nice if we actually fixed the problems instead of just trying to paper them over. This is trying to paper them over. This will make the problem worse.
Any further discussion? Seeing none, the question before us is the passage of House Bill 1258. All those in favor say aye. Aye. Those opposed, no. The ayes have it. House Bill 1258 passes. Mr. Schiebel, please read the title of House Bill 1097.
House Bill 1097 by Representatives Taggart and Weissman, also Senators Fields and Gardner, concerning occupational credentialing for military families.
Representative Weissman.
Thank you, Madam Chair. I move 1097 and the State Affairs Committee report.
To the committee report.
In State Affairs, we adopted one amendment that was largely technical and conforming in nature. In substantive part, we actually allowed a few additional service members into the scope of the bill, folks who serve our country through the NOAA, National Oceanic and Atmospheric Administration Commission Corps, also the Public Health Services Commission Corps. There's about 100 folks per DMVA in the state who do either of those things, but when you rotate out of those services, you are a veteran. Like other veterans, you get similar benefits, and when you are in service, it's not the armed services, but you are in service to the country, you might be moving around in similar ways, and we thought it made sense to include those folks, so we ask for your support of the State Affairs Committee report.
Representative Holtorf.
Thank you, Madam Chair. To the committee report, Representative Taggart is not here because he's in another committee, so I am here as a stand-in to say that Representative Taggart supports the committee report 110%.
Representative Weissman.
Yeah, thank you. And I was going to save that for the bill, but as you see, this is a jointly primed bill by myself and Rep. Taggart. We've been working on it together since the interim. As the Speaker announced earlier, our Joint Budget Committee members are hard at work across the street. He and I discussed, and I was going to go ahead and just present here on second reading, but credit where it is due. This is Rep. Taggart's bill. I've joined him on it. We are in league with getting this done together, so we ask for your support of the committee report.
Okay, any further discussion? Seeing none, the question before us is the passage of the committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report passes. To the bill, Representative Weissman.
Thank you, Madam Chair. So members, now to the bill. 1097 makes really a pretty modest change to our military occupational licensing framework. As Rep. Marshall and I spoke about on a different bill, military families are prone to move around a lot. somebody is in service in one of the armed forces or the commissioned corps that we just spoke of, very often they have family members who are members of a regulated profession. That means you need to keep your license active, and as folks have seen, we do a lot of interstate compacts, but portability across state lines is not always as smooth as it might be. We have worked on that for years around here. This bill situates in that course of work. We are making some conforming changes to a federal law change last year, change to the SCRA, or Service Member Civil Relief Act. What we're doing here in substance is recognizing the turbulence that relocation on military orders can cause in a family, and just trying to help members of regulated professions get back to work, stay at work, practice their profession, contribute to our economy by extending the term in which a license is valid in Colorado post portability. Other requirements to renew, to keep your license active, continuing education, comply with professional ethics, and so forth remain unchanged. So we ask for your support.
Is there any further discussion on House Bill 1097? Seeing none, the question before us is the passage of House Bill 1097. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The bill passes. Mr. Shebel, please read the title of House Bill 1094.
House Bill 1094 by Representatives Lukens and Soper, also Senators Roberts and Will, concerning earnest money deposits received after the Real Estate Commission has approved a developer subdivision registration and in connection therewith, allowing the use of developer subdivision earnest money deposits by accredited investors.
Woo! Representative Lukens.
Thank you, Madam Chair. I move House Bill 1094 and the Business Committee report.
To the Business Affairs and Labor report, Representative Lukens.
Thank you, Madam Chair. The committee, or the amendment that we made in committee, was a direct result from constituents in my district, specifically in Vail, that pointed out just one quick fix, and so we added that in to just clarify language, and we ask for a yes vote on the committee report.
Is there any further discussion on the Business Affairs and Labor Committee report? Seeing none, the question before us is the adoption of the committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The committee report is adopted. Representative Lukens.
Thank you, Madam Chair. Today we bring before you House Bill 1094, Developer Subdivision Reservation Deposits. This bill will expedite the investment in and development of certain development projects, particularly in rural resort communities that make up parts of my district. It would allow flexibility in use of earnest money deposits for certain development projects. We ask for a yes vote on House Bill 1094.
Representative Soper.
Thank you, Madam Chair. And members, this is by far the most exciting bill you will hear this year. There were so many people in committee to listen to this bill that I'm still amazed by it. We at least got one person. But it does two things. The earnest money after the commission for approval, and then it allows an accredited investor to be able to play more of a role in the development of the timeshare properties. Ask for a yes vote. It's a good bill. Thank you.
Is there any further discussion on House Bill 1094? Representative Titone.
Thank you, Madam Chair. And I just have a question about this, because, I mean, as far as I know about earnest money, that's used as a down payment on the unit that somebody's going to be buying. And, I mean, what this suggests to me is that the developer doesn't have enough money to build the project without the earnest money being used up front. I'm just wondering why they need to have access to all this extra money for these projects if they're planning on building these in the first place. And, what happens if that project doesn't get built? Then what happens to that earnest money that somebody put down for that unit? Do they get that back, or does that go away?
Representative Soper.
Thank you, Madam Chair, and thank you, Representative Titone. That's a great question. So first of all, this isn't earnest money of just any person. This is only for an accredited investor. And currently under law, to be an accredited investor, you must have $1 million in assets or more that are not your personal home or assets within that home. So that's beyond that. Second of all, the bill requires that as an accredited investor, you have to have certain disclosures that you know and understand, and that's listed on page 3 of the bill. So it will talk about things like where the funds are going to be delivered, when delivery of the funds will occur, how they will be used, any restrictions on the use of the funds. And through all this, it's optional. It's not like the accredited investor has to agree to any of this. They could fall under the standard rules for the earnest money. This is only if they want to participate as an investor. We're also talking about a different type of timeshare, one that is not just 1 week a year, but where someone may actually have 8 or 12-week interests within the year. So they're actually changing how the timeshare model is playing out.
Representative Titone.
Thank you, Madam Chair, and thank you for the answer for that question. I mean, it sounds like you're phrasing it that these folks become investors in the project. And I mean, if I invest in something, I'm expecting to get something in return for that. It doesn't say anything that somebody who is allowing that earnest money to be used, that they get anything in return. I mean, I don't see any incentive for anybody to want to do this kind of thing if they're just allowing their money to be essentially put into a more risky situation because, you know, they don't have a guarantee that the project's going to be built and they're not getting anything in return. So I don't understand why this kind of instrument is even being used if there's no incentive for that person to put their money up front. So just curious about that.
Thank you, Madam Chair, and thank you, Representative Titone. So this is only an opportunity to partner with consumers that invest in these particular types of properties. It's an option, and if they see this as an opportunity to invest in the development and also be a buyer by putting up your earnest money, then you're able to do both sides, both participate on the development side by leveraging your earnest money in the investment side. So if you're willing to take on that risk and you are an accredited investor, then our bill would allow that, but only for timeshares.
Is there any further discussion on House Bill 1094? Seeing none, the question before us is the passage of House Bill 1094. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The bill passes. Mr. Shebo, please read the title of House Bill 1130.
House Bill 1130 by Representatives Doherty and Lynch, also Senators Lundin and Hansen, concerning protecting the privacy of an individual's biometric data.
Representative Doherty.
Thank you, Madam Chair. I move House Bill 1130 and the committee report, and I have a second reading amendment as well.
To the Judiciary Report.
I move Amendment L006 and ask that it be properly displayed.
That amendment has been properly moved and is displayed. Representative Doherty.
Thank you. There was a drafting error on the original amendment in committee. If you all will remember the questions on digits, this just adds more language that was not added in the first place.
Is
And I
there
ask for
any
an aye vote.
further discussion about Amendment L6 to the committee report? Seeing none, the question before us is the adoption of this amendment to the committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. To the committee report. Representative Doherty.
Thank you, Madam Chair. Most of the changes in the amendments we ran in committee were designed to further align the statute with existing CPA regulations to ease with implementation of the bill after extensive stakeholding work, and we would ask for an aye vote.
The question before us is the adoption of the Judiciary Committee report. Seeing no further discussion, all those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The Judiciary Committee report is adopted. To the bill. Representative Lynch.
Thank you, Madam Chair. So this is a really important bill in that we now have all kinds of our biometric data that is out there. Everybody's got a phone with a camera. We are collecting tons of data that can be used potentially nefariously or for people that could profit off of actually having your biometric data. So some of the common sense things that this bill does is this bill requires the corporations to get individuals' consent before collecting and using their biometric data. The bill prohibits biometric data from being sold. Biometric data is too sensitive to be treated like a commodity. This bill requires businesses to delete a person's biometric data 1 year after an individual last gave consent or upon the individual's request. Keeping this information otherwise stored indefinitely presents grave security risks. And under this bill, people have the right to find out which companies have their biometric data and what specific data they have. This bill also threads the needle of making sure that we don't get in the way of law enforcement's ability to use that biometric data to help us keep our community safe. This is a great bill, and I would encourage a yes vote.
Representative Doherty.
Thank you. And just to add on briefly, we think this data deserves more protection than other types of data and simply should not be sold. And we're very proud to bring this bill, and we ask for a yes vote.
Is there any further discussion on House Bill 1130? Seeing none, the question before us is the passage of House Bill 1130. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The bill passes. Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
Rise and report.
Okay, much better.
You heard the motion. The committee will rise and report.
The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report it is under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1041 is amended 1053, 1076 is amended 1094, is amended 1097, is amended 1098, is amended 1100, is amended 1122, is amended 1130, is amended 1258, is amended passed on second reading, ordered and grossly placed on the calendar for third reading final passage. Senate Bill 29 passed on second reading, ordered, revised, and placed on the calendar for third reading and final passage.
Representative Froelich. Members, you have heard the motion.
012, Committee of the Whole.
And we will ask for it to be properly displayed.
And that, yes, thank you.
And that too. It is properly displayed. Please proceed.
Thank you, Madam Speaker. I just, again, want to reiterate that if we're going to be taking care of people in moments of crisis, we should be doing it financially as well after the fact. So for the legal aspect, I want to make sure we're only charging these people that are struggling that $25 an hour in their legal fees. And I ask for a yes vote.
Representative Mabry.
Thank you, Madam Speaker. Again, this amendment reflects a fundamental misunderstanding of how this works. Tenants aren't paying for attorneys. They're provided free legal aid attorneys when they can get those, which is a very small number of times through nonprofits. This isn't how the system works.
Representative DeGraff.
And it's punitive against the landlords. So again, we're taking a stand against the landlords to make them. This amendment will protect the landlords. As it will not preclude justice being done. It'll just preclude the overall hugely negative, what I would call a perverse incentive to actually go against, to side with frivolous cases, because assuming that landlords have deep pockets. So what this will, if you continue to allow the frivolous lawsuits, what you're going to do is you're going to only have landlords that have deep pockets, because you'll force all the landlords out of business, that you are going to force all the mom and pops out of business. So this protects the small property owner, the mom and pops that are doing the best that they can. They're trying to abide by the never-ending deluge of regulations that come out of this body, and trying to limit the damage. It doesn't preclude justice from being done. It just precludes forcing these people out of business for the purpose of the abolition of private property, which so many of these rules are geared towards. So I recommend a yes vote on this, because yes, the tenants don't pay for it, but somebody is paying for it, and ultimately the goal is to make the landlord pay for it. Again, this doesn't preclude justice being done and finding in the favor, but what it does do is it helps protect the small landlords that are just doing the best they can in complete opposition to the General Assembly.
Seeing no further discussion, the motion before us is the adoption of the first Armagost Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Luck, how do you vote?
No.
Representative Luck votes no. Representative Ortiz, how do you vote?
No.
Representative Ortiz votes no. Representative Bockenfeld is excused. Representatives Garcia and Joseph excused. Please close the machine. With 11 aye, 42 no, and 12 excused, the amendment is lost. Mr. Schiebel, please read the second Armagost Amendment to the Committee of the Whole report.
Representative Armagost moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Armagost Amendment L20 to House Bill 1098 to show that said amendment passed, that House Bill 1098 as amended passed.
Representative Armagost.
Thank you, Madam Speaker. I move the Armagost Amendment, House Bill 1098, 8002 to the Committee of the Whole, and ask that it be properly displayed.
Thank you. It is properly displayed. Please proceed.
Thank you, Madam Speaker. So again, we're back to the fact that we're just trying to take care of the people that are struggling and suffering in these situations, and we need to make sure that we're not gouging them when it comes to their legal protection. On the generous end of this, I understand attorneys need to make money too, but we need to make sure we're taking care of the people that matter in these situations, and this amount that an attorney can charge should not exceed $200 per hour. So this amendment would fix that to make sure that we are not charging people more than $200 an hour in these moments of crisis. I ask for a yes vote. Thank you.
Representative Mabry.
Thank you, Madam Speaker. Again, this is not how the system works at all. Please vote no on this amendment.
Seeing no further discussion, the motion before us is the adoption of the second Armagost Amendment to the Committee of the Whole report. Mr. Shebel, please open the machine and members proceed to vote. Representative Luck, how do you vote?
No.
Representative Luck votes no. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Ortiz, how do you vote?
No.
Representative Ortiz votes no. Representative Harrod, please close the machine. With 11 aye, 42 no, and 12 excused, the amendment is lost. That is all of the amendments. The question before us is the adoption of the report of the Committee of the Whole. Mr. Shebel, please open the machine and members proceed to vote. Representative Luck, how do you vote?
No.
Representative Luck votes no. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Ortiz, how do you vote?
Yes.
Representative Ortiz votes yes. Please close the machine. With 40 aye, 13 no, and 12 excused, the report of the Committee of the Whole is adopted. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar until Tuesday, February 20th, 2024.
Madam Majority Leader. Yes, Madam Majority Leader.
Madam Speaker, I move to lay over House Joint Resolution 24-1017 until Friday, February 23rd, 2024.
Seeing no objection, House Joint Resolution 1017 will be laid over until Friday, February 23rd, 2024. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar until Tuesday, February 20th, 2024 at 10 a.m.
Seeing no objection, the balance of the calendar will be laid over until Tuesday, February 20th, 2024. We do have time for announcements, introductions. Representative Weissman.
Thank you, Madam Speaker. Legal Services Committee members, this is a reminder that we have some work to do. 7:30 in the morning this coming Tuesday, the 20th. Everybody should have the information slip from nonpartisan staff. See also email from staff. We are keeping to the 7:30 time, notwithstanding the long weekend. There were scheduling conflicts that prevent moving it later, so 7:30 to 9 a.m. Tuesday morning, the 20th. Legal Services, please be on time. Thank you.
Representative Snyder.
Thank you, Madam Speaker. I have been granted permission to be excused on Tuesday, February 20th, from the Majority Leader. Thank you.
So approved. Representative Story.
Thank you, Madam Speaker. Members, CDC will meet on Tuesday, February 20th at, let's say 8 o'clock in room 357. See you then.
Thank you. Representative Holtorf.
Bipartisan, ma'am.
Thank you.
Bipartisan, ma'am.
Representative Holtorf.
Thank you, Madam Speaker. On behalf of the Veterans Caucus, we are going to do an ad hoc meeting immediately following this. It's going to be in room 206. And Representative Marshall has an important announcement on some things that we're working on just very quickly so we can get as much support as possible.
Representative Marshall.
Well, that was kind of a shock. I thought we were just going to keep it internal to the caucus real quick. But yeah, we're doing some support for a Marine Memorial that's in Golden that needs to have some helpful refurbishment. Our colleague that covers that area asked if we could get some veteran caucus support behind it, and I think we both are in agreement. Hopefully we can get the entire caucus in agreement to support it. So, thank you.
Great, thank you. Representative Soper.
Thank you, Madam Speaker. I've been granted permission to be excused on March 11th to 14th by the majority and minority leaders.
Thank you, so approved. Representative Mabry, do you have a special guest to introduce? Representative Mabry, do you have a special guest to introduce? I thought you did.
Thank you, Madam Speaker. Members, my mom is here today. She flew out because 6 months ago she got us reservations at Casa Bonita, so she's here for Casa Bonita.
That's awesome. All right, Madam Majority Leader, let's bring this home.
Thank you, Madam Speaker. I have a quick announcement. Members, if you have food in the fridge, please remove it, clean it out. Any food on your desks stored, please put that away or take it home, whatever it is. Madam Speaker, I move that the House stand in recess until later today.
The House will stand in recess until later today.